May please your lordship. Lordship, I am praying for listing of this four similar review petition lordship. Review petition lordship. Praying for listing lordship.
Review. My order.
Lordship.
What happened?
Lordship notice issue. Lordship petition entitled higher amount than your lordship passed the order to ask
For correction?
lordship.
Okay. We'll have it
Next week.
next week.
That's why it's number 22 lots. This data may not be taken up today, lots. May not be taken up today, lots.
Why?
22 lots. That's about this matter actually doing by the outsourcing counseling lots.
So
Not to come today, lots.
you're enjoying a stay?
No lots. No stay lots.
You are challenging?
Lots of the partial rejection of the amount of budgetary support. Lots.
Understood. But what are you challenging out there? You don't know.
I am not aware.
Okay. Know it and then mention. We'll take it up. Yes, next. Don't make a mention.
May it please your lordship.
Yes.
As far as item number 16 and 17, they are concerned, my lord. In this matter, my lord, in fact, urgency is there found, but Dr. Saraf is appearing. Learned Senior Counsel, Dr. Saraf.
Where?
In item number 16 and 17, he is appearing in this matter.
There's no name shown here.
But in the order sheet, it is there. Earlier also he appeared there. But urgency is there. Because they are enjoying stay order. They are enjoying stay order. I am for the respondent.
So you don't want to do it.
I want to do it.
Then do it.
What?
If Dr. Saraf is not appearing, I can very well take it.
Then I am obliged. Your lordship.
Why?
In item number 6, your lordship is directed at to file an additional affidavit. But lordship, the affidavit is ready. We are unable to serve the copy upon the petitioner as because she is out of station. And as contacted lordship, she has stated that it is to be served upon Bimal Sethi. He is also not available today. Now, till now, he is not available in court. So may I pray lordship may fix any other date. In the meantime, we are going to
2.
At 2. Lordship. But the counsel for the petitioner.
You say that
lordship,
out there
lordship.
that not
Lordship.
available, you file it and we'll take
Lordship,
it.
lordship.
In item number 44, the petitioner does not want to peruse this.
Item number?
44.
Yes, what is it?
It's a content petition, the order has been complied.
You want to?
We will not peruse,
You're not pressing.
not peruse.
Mr. Why?
The order has been complied with.
Ah.
Order dated 8.
It has been submitted by the petitioner that the order for which, for the non-compliance for which the incident proceedings was initiated have already been complied with. And as such, the petitioner would not like to further proceed with the say instant contempt proceedings. Taking into account that the order has already been complied with, this court drops the contempt proceedings.
May I please, your lordship, with the consent of the other side, lordship, I beg to mention item number 33. Here, lordship, we have sought for some clarification on behalf of the Finance and Taxation Department. Lordship may take it after 2 weeks and they are similar to others matter.
Take it up at 2. You get the only instruction which is required is as to whether you give him a notice or not. Isn't it? So, what is that? And this person has been enjoying a stay from 2020. Then,
Yes, ma'am.
if you have not given, you have made a best assessment judgment out there. Very well, you do it. And you have not given, again do it. It is only him. He has submitted another thing that there is a question of limitation. Look into it. For that, what else do you require instructions for that? No, we'll take it.
Two other similar methods can be taken up to also.
No, if it is not there in the list, I won't. Next.
Your lordship, I beg to mention item number 32 of daily read.
Yes.
And the adjourn for the day. And the adjourn for the day.
Why?
The brief is misplaced. The brief is misplaced.
You take the second file. I have a second file, na? Take it. Next. Here, Madhav.
Miss, please, Lordship, Lordship, I take to mention for listing on WBC, my lord. And this matter may be fixed on 11/8/2023, my lord. It is on-
Mention it before the court number 5, which is taking up bench 5, senior list. Mention it there. Why should I take it?
Item number 1. 1, 2, and 3.
I am for two, my lord.
Yes.
Yes, yep.
Can you do it?
Let's receive instruction, Lordship.
These are matters pertaining to those wastelands,
VCR lands,
the village grazing
Yes,
lands.
these are the-
Gopal, sir.
Mr. Sheikh,
My lord,
we do one thing. They say that you have to file fresh applications.
My lord.
You file fresh applications
Yes,
and they will consider,
my lord.
they say, I will put this thing which is there, the instruction, and not to disturb you till you are in possession, not to disturb you till the decision of this.
Lordship.
That's all.
Yes,
Mr. Botakur, that is, I think, the best way.
My lord, here, my lord, whether in the instruction it is mentioned, my lord, quantity of land.
no, that is as per land policy, that will be.
That will happen as per the policy. I can't help.
Yeah.
Okay, and you just ask me to have it parted. Well,
My lord. But it is mentioned in the cause list as part,
They have,
my lord.
they have put it as parted, but there's nothing
sir.
written out.
As your lordship written that it is
They have made it out.
hard in land.
Okay. The 3 petitions before this court have been filed by the petitioners challenging the eviction proceedings. Eviction proceedings.
My lord,
First
in
one
my
eviction.
case, my lord, it is not eviction, but
First one, eviction proceeding.
Challenging the eviction proceedings
As well as,
as well as
Hello.
the non-settlement of land in favor of the petitioners pursuant to the application so filed by the petitioners. The lands wherein the petitioner are presently possessing are village
grazing reserve, VGR.
grazing reserve. As per the judgment of the Supreme Court in the case of Jakpal Singh and others versus the state of Punjab and others reported in 2011, 11 SCC 396. The lands village grazing reserves, which are community lands, cannot be settled. It is under such circumstances that the present on 3/8/2023, this court had sought for instructions as to whether the petitioner's application for settlement could be considered in respect to other wastelands of the government of Assam. Mr. S. Dutta, the learned counsel appearing on behalf of the Revenue and Disaster Management Department, have produced before this court a communication issued by the Additional District Commissioner, Revenue Borpeta, dated 7/8/2023. In the said communication, Pusto, the contents of the said communication are reproduced hereunder, taking into account its relevance. এইখিনি পৰা দিব, হা? এই গোটেইখন দি দিব এইখিনি। From the above quoted communication, from above quoted contents of the communication dated 7/8/2023, it reveals that providing allotment of settlement of land to the petitioners may be considered in the wasteland of the government of Assam as per the government land policy, subject to availability of government wasteland and fulfillment of eligibility criteria by the applicant. It was further mentioned that the petitioners are required to apply afresh for allotment of settlement of the land, subject to genuineness and authenticity of the application. This court also finds it relevant to take note of that the said communication dated 7/8/2023, the contents of which have been reproduced herein above, was forwarded to the learned Standing Council of the Revenue by the Joint Secretary to the Government of Assam Revenue and Disaster Management (S) Department. Meaning thereby that the Revenue and Disaster Management Department (S), what is S? Settlement.
Settlement.
(S) Department also agrees to the stand of the additional Deputy Commissioner, additional District Commissioner Revenue Borpeta. Also agrees to the stand taken by the additional Deputy Commissioner, District Commissioner Revenue Borpeta in the communication dated 7/8/2023. This court further keeps on record the said communications and collectively marks the same with the letter X. Taking into account the above, this court therefore disposes of the 3 writ petitions on the basis of the stand so taken in the communication dated 7/8/2023, the relevant portion of which have the contents of which have been quoted here in above. This court grants the liberty to the petitioners. At this stage, this court also finds relevant to take note of the submission of Mr. S. Dotto, the learned counsel, Standing Counsel for the Revenue and Disaster Management Department, who submits that as per the extant laws, the petitioner is required to submit the applications for allotment of settlement of land to the Bosundara what? That is the policy now?
Yes, that's it. Yes, Bosundara 2.0.
As per the
Bosundara scheme.
Bosundara, in terms
Mission,
with
Mission
the
Bosundara.
Huh?
Mission Bosundara.
In
2.0.
terms with the mission Bosundara.
Yes.
My lord, regarding Vision Bosundara, my lord, application date is over already.
Hmm.
What Bosundara is in operation, my lord, that application date is
Time to
over.
time, it will be reopened, Lordship.
No. They are going to submit. Otherwise, for years, this will not happen. Or are they going to
Yeah,
take
they
it
are
to?
going to. Yeah. Lordship.
My lord,
It will-
Bosundara may not be
to
referred.
submit it to another. So, accordingly, this court therefore grants the liberty to the petitioners to file applications seeking allotment public settlement of land as per the
Land policy of
Extent-
2019.
land policy of 2019 of the government of Assam. The respondent authorities, that is the Deputy Commissioner, District Commissioner, Borpeta, as well as the Revenue and Disaster Management Department of the Government of Assam, shall duly consider the applications of the petitioners and also take into consideration that the instant applications are a continuation of the applications which the petitioners had filed earlier. It is, however, it is further made clear that till the disposal of the applications of the petitioners, the respondent authorities shall not take any coercive actions against the petitioners. With the above, the petition stands disposed.
Obliged.
There, come on.
And number 4 and 5 promotion.
Yes, Mr. Payang, what is your matter?
My lord, item number 4 is for enhancement of compensation,
Enhancement of?
compensation of land acquisition.
And 5?
5 was original case, my lord, for payment of the compensation. For payment of the compensation, 5 was filed. My lord. That it is
For enhancement of the compensation.
no, 5 was filed for it. My lord, initially 5 was filed for
Enhancement of what compensation?
land acquisition compensation.
Why are you before in a writ?
Probably, my lord, they filed a petition before the district commissioner, my lord.
Huh?
They filed.
This is done under what provision?
this-
Yes, madam. The petitioner counsel is not aware. Acquisition done under what provision? That are you aware or not, Mr. Payang? Acquisition done under what provision? Huh?
64 Act, my lord. Under 64 Act, my lord.
64 Act.
Yes.
That if you are aggrieved, why you are not filing a application under section 12?
Six.
Have you filed?
Application is filed, my lord.
Then what has happened?
That is pending, my lord.
Okay, there will be. Madam, you dispose of the deputy commissioner,
Deputy Commissioner, my lord.
dispose of the application and if you and refer it to the collector, to the district judge.
Yes.
That's it.
Yeah.
This court can't dump on all this prayers and all for enhancement or a payment of air. If you have not got any amount out there, you have the,
Page 26, they have left.
hmm?
Page 26,
The first writ petition is where?
59.
Double three.
First writ petition was, my lord, that.
We have two writ petitions.
Yes, my lord.
One is WPC number 5922
Yes, my lord. That is for enhancement.
for enhancement.
Yes.
And what is 7308?
That was for originally for the, my lord, compensation which was not paid in time. That is paid already.
So you have nothing.
Nothing.
Second, you have 7308/2019, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous and as such would not like to press the instant petition. And what is this case record of what suit? Huh, Ruki,
I-
whole record.
What record?
Some suit is pending, title suit 83.
That was not,
Record
that was
83.
not probably in this case.
Huh?
That was not probably in this case.
এটা কোপায় আছে সব LCR 5922 লগত আহিছে এইটো wait. There's some order passed with
I was not the council earlier. My lord. I've been engaged.
hmm
I have been engaged newly, my lord.
I don't know. Thereby When it's 8.1, yeah, 19.1, then now what the case? Show me your representation dated 1/10/2019. Is this one?
Yes, madam, 26.
And they have not disposed of. You have to do it. These are section 12.
Yes.
The petitioner herein is aggrieved by the inaction on the part of the Deputy Commissioner Kamruk for not taking action inaction on the part of the Deputy Commissioner Kamruk for not referring the request so made by the petitioner to the court for determination of the actual market value of the acquired land. The record reveals option 64 that for construction of a bridge over river Brahmaputra connecting Panbazar, North Guwahati, a notification dated 29/5/2008 was issued under the provisions of section 3(1) of the Assam Land Requisition and Acquisition Act 1964 for acquisition of different plots of land as mentioned in the said notification. In terms of the said notification, 3 plots of land of the petitioner covered by dark numbers 984, 985 and 986 of KP Patta number 138, 131 and 85, measuring different areas including residential houses were acquisitioned. Subsequent thereto, separate notices dated 5/2/2019 were issued to the petitioner in LA case number 17/2018, asking him to hand over the possession of the acquired land to the circle officer of North Guwahati Revenue Circle. It is the case of the petitioner that the compensation which was awarded was not in terms with, was not the compensation of rupees 25 lakhs per bigha which was awarded to the petitioner was not was not paid, was not fixed by taking into account the market value of the land in question. It is the specific case of the petitioner that the amount to which the petitioner ought to have been, the case of the petitioner, that the market value at that relevant point of time when the notification was issued for acquisition of the land at that relevant point of time was rupees 40 lakhs per bigha. It is under such circumstances that the petitioner had submitted an application under section 12 of the Assam Land Requisition and Acquisition Act 1964, seeking a reference to the court to determine the actual market value of the acquired land. However, although it is the further case of the petitioner that although the said application was filed and received as far back as on 1/10/2019, but 4 years have already passed by But 4 years have passed by and the respondent
Number 2.
number 3 have not taken any action on the same. And the said application continues to remain pending. This court have duly taken note of section 12 of the Assam Land Acquisition and Requisition Act 1964. Section 12 being relevant is reproduced here in under. Next. From a perusal of subsection 12, clause A of section 12(1), a mandate, a statutory duty has been imposed upon the collector in every case where any person aggrieved by an award made under subsection 3 of section 11 makes an application requiring the matter to be referred to the court. Award has been passed.
Yes.
It is further amended as per subclause B, as per clause B of subsection 12 of section 12(1) of the said Act of 1964. No, it will not. In that view of the matter, as a statutory duty is cast upon the collector, the collector, that is the respondent number 3, was duty bound to make the reference to the court in terms with the application dated 1/10/2019. Under such circumstances, now, this court further finds it relevant to take note of that a delay in making the reference has the effect of causing serious prejudice to the state also. In as much as if in the eventuality the awarded amount is enhanced, the claimant would be entitled to interest at the rate of 9% for the first year, and thereupon 15% after the completion of the first year. This interest is to be calculated from the date of taking over of the possession. Taking into account the above, this quote under such circumstances, as the next part, under such circumstances, as a statutory duty has been cast upon the respondent number 3 to make a reference, in terms with section 12A of the Act of 1964, this court directs the Deputy Commissioner, Kamrup Rural, and directs the respondent number 3 to forthwith and not later than 15 days from the date of passing of the instant order shall refer the dispute to the appropriate court full stop. Ms. S. Sharma, appearing on behalf of the respondent number 3, shall communicate the instant order to the respondent number 3. Full stop. Before parting with the record, this court finds it relevant to observe that the Revenue and Disaster Management Department, as well as who is otherwise in charge of the acquisition proceedings, shall enlighten the deputy commissioners as well as the collectors that delay in making the reference in effect would cause great prejudice to the state in the eventuality that the awarded amount is enhanced. Next. This court also takes note of that records of title suit number 83/2018 was called for. Taking into account the order so passed, the registry is directed to forthwith return the record to the court from where the same have been requisitioned.
Number
Madam
7.
Mahanto, this is you see what is the problem with these revenue officials, more particularly the deputy commissioner, they keep this reference applications pending. And thereby one day or the other it will go. The moment it goes, the possession, it has to be taken from the date of taking over the possession. And 15% is not a matter of joke.
My lord.
In 1 lakh, it will be how much? 15,000?
2000.
He's getting 25 into 3, 75 lakhs. 75, just imagine 15,000. Your money, her money. Because of the lapses on the part of the deputy commissioner. Next.
7 and 8 for admission.
Capricorn.
Yes.
This is the my lord, ex gracia.
You are appearing for which one?
I am for my lord 7, my lord, first.
7.
For the petitioner.
Kiran Bola Loskor.
Yes, lordship, my lord.
Huh?
Lordship.
You are the second wife.
Second wife.
Then what right do you have?
My lord, in fact, my lord, petitioner number 2, who is the my lord, daughter of the petitioner number 1, my lord.
Whatever may be. How do you have a right?
And if my lord, law of inheritance is applicable,
The law of inheritance, is your marriage recognized by law?
that is my lord not recognized.
Then
The first wife,
isn't it considered to be a nullity?
yes.
Then
In that case, my lord, petitioner number 1, she is not entitled. My lord. So petitioner number 2, my lord, who is the daughter of the petitioner number 1, my lord. She has also been, my lord, issued the certificate, my lord, certifying that, my lord, she is the daughter, my lord, of late Martia, my lord. who is the husband of the first wife, respondent number 4, my lord.
So you have a dispute as regards the respondent, as regards the petitioner in the other petition.
Lordship.
Then why are you before here?
In fact, my lord, that
Should
was,
this court decide between you and her? Tell me.
in fact, that is admitted by the, my lord, authority as well as.
No, authority may do whatever may be. That is the different thing. You take the authority, decide among and fight out, both of you fight out the way before the civil court. This is not the forum for deciding all these things. How can you decide all these things here?
In fact,
Whether the second wife obviously is not entitled. That's the decision I have already given.
yes,
Now, as regards whether she is the second daughter or not, whether illegitimate, whether a marriage, if it is not done properly, or if it's a nullity, would that be considered in law to be a child?
lordship.
Show me that.
So that is, my lord, your lordship is aware that, my lord, to the effect their judgment. of-
Show me that a marriage which is
Yes,
a nullity,
yes, yes,
the daughter or the child born therein
yes,
would be entitled to the interest.
lordship. That is here, my lord. There is a, my lord, case, my lord, cited, 2011 SCC. My lord, it is, already settled that, my lord, the illegitimate child, they are entitled to the property, my lord, inherited by the parents. My
Property,
property, my lord, inherited by the.
she'll be entitled to the property of inheritance from the parents.
Also self-acquired, my lord.
Huh?
Also self-acquired property, my lord.
Whatever may be of the parents.
Yes,
But is it of the parent? Out here,
yes, my lord.
who gets the ex gratia?
Ex gratia, in fact, my lord, the martia, my lord.
Does the martyr get? No.
Yes, my lord.
Who gets this? 5 lakhs?
So that is.
The next of the kin.
Next of kin, my lord.
So if the next of the kin gets it, the property belongs to whom?
That is self-acquired property of.
It can't be the self-acquired property. If the property will belong to the legitimate wife. If it was the property of the father, then you are entitled to, as per the judgment.
Yes,
But if the compensation is to be paid to the next of the kin,
lordship.
then the property is her. Then how do you get it? You are not the illegitimate child of her. How do you get it?
In fact, my lord, petitioner number 2, my lord. She is also before your lordship, my lord.
Who?
That is the daughter of the, my lord.
That is what I am saying.
Yes,
The petitioner number 2 will have a right over a property belonging to her father or mother.
yes,
Is the property of ex gratia payment to be is of the father or the mother? No.
Yes.
It belongs to the next of the kin. The next of the kin is she. How do you get it? How do you imply that judgment?
in fact, as per, if I am not wrong, my lord,
Hmm.
that judgment, as per that judgment, my lord, property is to be, my lord,
Absolutely. The father's property, you may have a right.
Yes.
But are you saying that ex gratia is paid to the father? No.
yes,
The ex gratia is paid to the next of the kin.
yes,
So next of the kin is she. So the property devolves upon her by the scheme.
Yes.
When she gets it, you have no relation with her.
in fact, authority decided to, my lord,
Authority, whatever may be.
your lordship kindly come to, my lord, there, my lord,
Authority can't decide all these
that
things.
is their communication.
And the next thing is, as regards why the deputy commissioner has taken her this thing and directed not to pay her the pension. Yes, deputy
Yes.
commissioner, you have done this. What is all these things? How can you stop a monthly pension?
Yes. Annexure.
Can you do that? After a pay order has been given, the pension order has been already given by the accountant general or whoever, the director of pension. How does the deputy commissioner do all these things? The second writ petition, isn't that?
Yes.
That-
Second petition is that.
You have no business to do all these things. You want to recover out there, recover, do one thing if you have any problem.
This is my pension account.
Your lordship may kindly come to page 16, my lord.
For what?
For a moment, my lord, this is, my lord, well, communicated by the authority, my lord, enclosing my name also, my lord.
Show what?
That is at page 16, my lord.
Hmm.
In fact, the earlier, my lord, grant was also divided among the two wives, my lord, earlier, my lord.
Earlier it is okay.
Yes,
Well, they all do it. I would have understood. Your husband have changed the religion. Then obviously he will be entitled to. Did he?
no,
So how can I help you? If your marriage is illegal, which is a nullity in the eyes of law, how do you get anything? Tell me. You may very well ask tomorrow. I am also entitled to having no relation also. You can. Can it be given? It has to be recognized by law. How is it recognized as regards the second wife? Can't help it. But as regards the illegitimate daughter, she may be entitled to the property of her father. But show me that the ex gratia payment was to be paid to the father, then you may have a right. But if it is to be paid to the next of the kin, then she has the only right. You don't have a right of share from her. You have a right of share from your father. That is the judgment of the Supreme Court. Yes. Show me. Have it? Nothing?
my lord, you'll also kindly fix, my lord, some other day. My lord, I will respond to your lordship, my lord.
Chalo. But the other ones, I'm disposing of, setting aside that one. You have no business out there. And how much compensation you are asking from the Deputy Commissioner?
5 lakhs.
You are,
5 lakhs.
You're asking compensation?
Yes.
Very good. From her salary, then it will be deducted. You deduct from his pension.
Pension account.
Where are you asking for salary? Yeah. No. You have received the 5 lakhs.
Yes.
That is okay. But are you asking asking compensation from this Deputy Commissioner?
No.
Why? Whenever he gets the pension, we'll deduct it.
Yes. Pension
This
account.
5 lakhs.
Yes.
Then he will know. Hello. This okay. This I will take it some other day. But this one I dispose it of. This you have no business out here. As regards the monthly pension also, you have no right.
Yes.
You may have, because the monthly pension is given only to those persons.
In fact, my lord, this number was usually given by the authority to the, my lord, before the government, my lord. So that can be dispersed to one, my lord, account.
But
number.
first of all, that power which has been given by the authority has to be exercised as per the pension code.
Yes.
The pension code would only be applicable if you are a Mohammedan.
Yes.
Otherwise, it won't. I can't help you. WBC number 5747/2018. The instant writ petition has been filed by the petitioner, challenging the letter dated
21/4/2007. Yes. 21/4.
which are the challenges?
21/4/2017.
Page,
Page 20. 21. Annexure B.
you are challenging this, na?
This one.
Challenging the order dated, the communication dated 21/4/2017, issued by the Additional Deputy Commissioner Karbi Anglong Diffu, whereby the branch manager SBI Hauraghat branch was directed to stop the withdrawal of the amount from the account by the account holder until further orders, and to submit detailed bank statement as on the date after deposition of the said grant amount to the office for taking necessary steps from this end. It further reveals. Now, full stop. This court further finds it relevant to take note of that a petitioner herein is the wife of one, what is his name?
Sadhuni Lashkar. Sadhuni Lashkar.
The wife of
Wife of Vidyadhar Lashkar.
one Vidyadhar Lashkar, since deceased. Full stop. On the basis of a pension payment order number ADP/PPO/GPO/2015/019649, the petitioner herein was receiving the family pension. Is it pension or family pension? Receiving pension,
Own pension.
was receiving pension. Full stop. It is further relevant to take note of that being the wife of late Vidyadhar Lashkar, who was a martyr of the Assam agitation, and in terms with the scheme of the Assam government, whereby the next of the kin is granted ex gratia compensation to the tune of rupees 5 lakhs. The petitioner applied for the same. Pursuant thereto, an amount of rupees 5 lakhs was deposited to her account. It is the further case of the petitioner that the amount of rupees 5 lakh has already been withdrawn by the petitioner. Subsequent thereto, there were certain complaints being filed by one Sri Kiran Bala Lashkar, claiming that she, being the second wife of late Vidyadhar Lashkar, was entitled to half of the said amount. On the basis thereof, the additional Deputy Commissioner Karbi Anglong issued the impugned communication dated 21/4/2017, whereby the branch manager, SBI Hauragrad branch, was directed to stop withdrawal of any amount from the account of the petitioner. On the basis thereof, the branch manager, Hauragrad branch, informed the petitioner that on the basis of the communication dated 21/4/2017, issued by the additional Deputy Commissioner Dipu, withdrawal from the account of the petitioner have been stopped. It is the case of the petitioner that as she is a regular pensioner, as she is a pensioner, and her pension is disbursed through her bank account. The actions on the part of the respondent, additional Deputy Commissioner Karbi Anglong, to direct the branch manager, SBI Hauragrad branch, to stop withdrawal have caused serious prejudice to the petitioner. As she is not being able to withdraw her pension amount. It is under such circumstances that the instant writ petition has been filed. It reveals from the record that this court, by the detailed order dated 24/8/2018, issued notice and further directed and further stayed the communication dated 21/4/2017 issued notice and in the interim stayed the communication dated 21/4/2017 and further directed the respondent, State Bank of India, not to act upon the said communication dated 21/4/2017 and permit the petitioner to withdraw her pensionary benefit. It has been submitted that pursuant to the said order dated 24/8/2018, the petitioner have been permitted to make withdrawals from her bank account. I've also heard Mr. who is appearing pension, yes, Ms. S. Sharma, appearing on behalf of the additional Deputy Commissioner. Dipu. And this court has specifically inquired as to what authority and jurisdiction did the said officer exercise to direct the SBI Hauragrad branch, the branch manager of the SBI Hauragrad branch, to stop withdrawal of the amount from the account of the petitioner and thereby affecting her pensionary benefits. Yes, madam, your answer.
Indefensible.
Eh?
Indefensible.
The learned counsel Ms. S. Sharma, with due fairness, submits that the additional Deputy Commissioner Karbi Anglong Difu ought not to have done the same, taking into account that stopping the withdrawal, taking into account that the stopping the withdrawal of the stopping the use of the petitioner's bank account wherein she receives her pension would render the petitioner would affect the livelihood of the petitioner. Taking into account the above, and this court having seen that there is no that the additional Deputy Commissioner Karbi Anglong Difu had did not have the authority and jurisdiction to exercise the said to have issued the communication dated 21/4/2017. This court therefore sets aside the communication dated 21/4/2017. This court further directs, I think that is enough. With the above, the instant petition stands disposed.
Pension account.
Ikon dekhao. The learned counsel appearing on behalf of the petitioner submits that he requires some time to apprise this court as to some time to take appropriate instructions and also prepare the case as to whether the daughter, whether the petitioner number 2, who being in would have a right over the ex gratia payment which have already been disbursed to the respondent number.
Code.
List the matter again.
After 2 weeks.
When?
Your lordship may pick anything.
List the matter again on 28th of August 2023. You give your names in the slips. I don't refer to anybody's name. Unless submissions are made.
If you plan.
9. Item 9.
What? Petitioner?
Petitioner is not available.
Petitioner has not been appearing. Why?
I don't know.
And what is your stand?
Lordship will verify and pay them.
No, you see, the petitioner, I normally don't read the petitions, but yesterday I thought that everybody is so fast, I'm so slow. So let me go through the petition. While going through the petition, it is not clear how much the petitioner received.
It is not admitted, Lordship.
No, it is not clear whether the petitioner received 10 lakhs, 54,000, or he is yet to receive that. It's not clear. If you see the line, paragraph number 10, the petitioner therefore prays for a direction to respond to immediately release the balance amount of so and so only. Then you see again here, para 7, that from the replies given to the petitioner, it is seen that a total of rupees so and so is due to the petitioner. The balance of rupees so and so only has not been paid to the petitioner. Meaning, has he received something?
Lordship, as per the RTA report.
RTA, he is only entitled to 3,27,000.
That's what.
So, the instant petition has been filed. Seeking a direction upon the respondents to make the balance payment payable to the petitioner in respect to the work done by the petitioner. It reveals from the records, it reveals from the pleadings as well as the documents enclosed that the respondents issued a notice inviting tender for work of construction of treatment plant, charging of filter media, paragraph 3 to 6. The petitioner submitted his bid and was allotted the said work. It is the case of the petitioner that the petitioner duly completed the said work as per the specification and within the time stipulated. It further transpires from the pleadings that the petitioner received certain amounts of money, but however the petitioner have not received the balance for which the petitioner had represented before the authorities time and again. This court at this stage finds it relevant to take note of. Madam, which is the work we are concerned?
Lordship, it is this order. Work order dated 29/10/11.
29. Is it 29 or 28?
29. As per the annexure A in page number 9.
Huh?
Annexure A in page number 9.
This is what?
The work order which was issued by the PHE department.
29/10/2011. Oh, this is work for what? Work order for the purpose of construction. Now kindly come to page 18, 17, 18. Handing over. Information of the RTI. Huh? You see, these are the various works. We are concerned with which one?
Lordship, these are the same work. Name of the work is the construction of treatment plant, filter media, UGR, pump house, etc., etc.
It is further relevant to take note of that annexure E of the petition, wherein there are certain replies being given by the State Public Information Officer of the Office of the Executive Engineer PHE, Bukakhat Division. From a perusal of the said information so given, it is seen that the certain balance payments could not be made on account of non-availability of the fund. Next. Taking into account that if the petitioner had duly completed the work, the petitioner would be entitled to the amount as per the contract. Ms. So-and-so, the learned counsel appearing on behalf of the respondent, which department?
PHE, all the respondents.
PHE department had submitted that how much the petitioner would be submitted, that the fact that the petitioner was allotted the work in question is not in dispute. But the actual entitlement can only be ascertained after due verifications. Taking into account the above, this court therefore disposes of the instant writ petition with a direction to the respondents, and more particularly the respondent number 2, to take appropriate steps for verification of the records, for verification as to whether the petitioner is entitled to any amount in respect to the contract in question, works allotted to the petitioner. And if it is found that the petitioner is entitled to any amount, the same be paid in terms with the judgment of the Kamser Ali versus so-and-so, reported in so-and-so. The said verification be completed within be completed within 1 month from the date a certified copy of this order is served upon the respondent number 2.
Obliged, Your Lord.
Then I need time until 2 p.m. Malad, they're going to respond.
What
The
is
Deputy
this?
Commissioner. The Deputy Commissioner Dhemaji.
Also, I am assailing the eviction notice that is
Oh, Exuna.
action, but that was converted to Miyaji Patna here also. That is at page,
Let us see the eviction notice.
that is at page 16.
Eviction notice says DAG number 46.
Yeah, that is the old tag number, and that has been converted to 337 in the new.
Now, thus you see, you have been given patta number 76 of DAG number 337.
In the remarks column, your lordship,
Now, how do you link? How do you link? This is from DAG number 46.
in the
Record has
remarks
been
column, your
corrected
lordship,
in
at
DAG
page
number
9.
76 of Exona, patta number Iman of village Iman, map number 46. What is this? Are you right? Because here the land which have been sought to be acquired is DAG number 46. Why you are saying about how does this land come into being? Mapor. This is some 46 number Exona patta.
Lordship.
So the patta is 46, but here the eviction notice is in respect of DAG number 46. Is it said? See?
It says map number 46 in the eviction notice.
Oh,
Tag number, your lordship.
you have
But-
wrongly
Jamabandi.
translated.
In the Jamabandi,
Mr. Sharma, you have wrongly translated. See, you are hereby directed and observed that you have been illegally occupying the raising wall in government land in Momurar map, Dhemaji, Moza in DAG number 46.
yes, that is it. That is
And what is there in Assamese? Read it.
map or map. It is.
Then where the DAG? Mapor Cialis number Dagor.
That
Adharan
map
Sokari.
number is mentioned in the remarks column, your lordship, at page 10, your lordship, in the Jamabandi. If your lordship comes to the vernacular one, page 11.
Exona Pottar. But this is Exona Potta.
Exona, that is the 46 map or.
That is different from DAG. Isn't it?
But
You see, Exona Potta means that is a land of annual settlement. But it is a private land. Okay. Because in respect to lands which are being allotted or settled, these are pattas. But the DAG, if it is only the DAG, then it's a government land. Because patta is a settlement. So when it is mentioned as Mapor Cialis number Exona Pottar, so isn't this from 46 number annual patta?
Yeah, that is it, your lordship, that is, but it is mentioned in map number 46.
Where is Mapor? Mapor 46 number Exona Pottar.
It is
Dagor Mati. See, Dagor Mati 76 number. Yeah, kind of. Loma Dhuri.
ইয়াৰ দ্বাৰা আপোনাক নিৰ্দেশ দিয়া হয় যে ধেমাজি মৌজাৰ মৌমাৰী মেপৰ 46 নম্বৰ দাগৰ সাধাৰণ চৰকাৰী বৰ্তমান জান হৈ থকা মাটিত আপুনি
No,
বেআইনী
no, that is that. I'm not on that. I'm annexure A. You see, it's very difficult to read. Page 11. Too small.
পট্টাদাৰৰ নাম
See, here the Mapor Cialis number Exonia Pottar. So the reference is, huh?
টাৱত দাগৰ মাটি
46
৭৬ নম্বৰ ম্যাদিত জমা ধৰি নথি সংশোধন কৰা হয়
So it was made to 76
বাইলত
from that annual patta.
লাটমণ্ডল
46 map number was converted to 76.
76, that was been converted. But you were earlier given an annual patta?
But that is not there, your lordship.
Huh?
I don't have that in instruction, your lordship.
No, no.
Then-
How did you get this land?
By making application for conversion of this.
Show me your sale deed. How did you purchase this Exona patta? There cannot be a sale deed. Nobody registers it.
No, your lord.
It can't be a registered document. Is it? Yes, 2 o'clock. Get your instructions. 2 o'clock.
11.
Thank you, your lord.
Hmm.
My lord, your lordship kindly see, my lord, the last order that is passed by this honorable court. My lord, as per the order, the railway has filed affidavit, my lord. But the other respondents, my lord, Revenue Department, they did not file affidavit.
Not necessary.
My lord.
Yes, you are paying for whom?
On behalf of S. Hazarika, Railway Council.
Okay, you have nothing to do. You are revenue.
Type for railway.
Yes, what is all these things for revenue land also you are exercising 64?
So, my lord, the
How are you exercising 64 for railway acquisition?
my lord, originally it was 2013. Then that was dropped. Then again, this notification was issued for broadening of Lamding to Huzai land. That for that, my lord, under 64 Act, this
How can
notification
you
was-
put a 64?
but the calculation was made under section under the provision.
Obviously 33, but you see the scope is otherwise very less. But anyways, now what has happened?
Now, my lord, out of the estimated amount,
Have you passed the award?
yes,
When?
that was in 2000. Yes, 2017.
Where is the award?
That calculation I have.
Where is the award? When did you pass the award? Award will be passed by the deputy commissioner.
Yes, this is the deputy commissioner.
When did you pass the award? And you passed the award under the 64 Act.
And part, the substantial amount they have received though.
It's a different thing. I'm only asking you, when did you pass the award? He's asking for more amount, isn't it?
Yes, my lord, under 13, under section 13.
So this.
No, but if you are asking for more amount, how are you filing a writ?
Not, my lord, received any amount actually. my lord.
Stupid.
I have
No,
not received
out
any
of 4
amount. my lord.
crore, he has already
That's why-
received 3 crore.
That's why, my lord.
Where is it?
Yes,
My
that is
lord,
the
Last
last
Yes.
order, it is reflected also, my lord.
Some of
Where?
the petitioners got, my lord, but we have not received any amount, my lord.
No, no, it's okay.
Of
But
course.
where do you have? Yeah.
That's why.
Out of the total compensation amount assessed at rupees demand, an amount has already been dispersed to the beneficiaries.
And that is part of the affidavit also, by paragraph 6.
Paragraph 6 of the Deputy Commissioner Act.
Okay, so this has been paid to the
Paid.
beneficiaries. Okay, now remaining, why haven't you paid the earlier amount?
That the instruction awaited.
Because
by-
they have already deposited more than 4 crores.
Yes, yes,
Then why you have not given?
that is the deputy commissioner.
The Deputy Commissioner. That's why.
That's why. my
But
lord, of
earlier
last
it was
of the-
Hojai, now it is again merged with Nagaon. That is the difficulty there.
There's no difficulty out there. Who is going to pay the interest for that? Who is going to pay the interest? And if he has any quarrel, why you are not going under section 12? What is all these things, filing a writ petition out here?
But,
They have passed an award, have you passed the award? We'll
At the
take it up
least
at
I
2.
have- I don't know.
No, we'll take it up at 2. If you have the award, you just bring the award. Ask them to get me any copy out there.
Can it,
Then two,
can it be
Three.
some other?
three, three. Hosai is what? Is it in America?
Now.
In America also you get it. 3 o'clock, I'm not asking for the original one. Ask them to send you whatever it is. Just let me know when the award has been passed. Then I'll ask him to move on the section 12 and immediately you refer it. If he has any amount to be received.
Like,
3. All these things, these type of matters shouldn't remain out here in the writ.
My lord, in this case, my lord, we have not received any amount, my lord. That is our grievance, my lord. My
If
lord,
you have
sir,
not received your amount, you will get your amount. Don't worry.
My lord,
Don't worry.
but,
If you have not received the amount, will just get your instructions
that's.
as
that's
to
why,
whether
my
you have
lord,
received.
that's why, my
And
lord,
see the petitioner. And have you paid the court fee for everybody? 60 rupees. Pay the court fee in the meantime. At 3 is next.
My lord. Completion certificate, my lord, page 70. Column 12, my lord. Up to date bill amount 7,11,700. Then, my lord. Page 28, my lord.
What do you say about paragraph 13 of the affidavit filed by the Revenue Authority?
Paragraph 13, my lord. Not yet approved by the. In this regard, my lord, subsequent development is there, my lord. Subsequent letter was issued by the under secretary building, my lord. Whereby asked to the chief engineer to submit the fresh proposal.
Yes, madam, why haven't you paid when the chief engineer, everybody said that he has completed 31% of the work and is entitled to this 7,11,000?
My lord, it's, disaster management was not communicated about till date, my lord.
Hmm?
Our department is not communicated till date, my lord, the public works department.
Then kindly see paragraph number 9 of your affidavit. 9 and 5.
It is true, my lord, but our department has not communicated, my lord. Till date, my instruction is that, my lord.
Hmm?
We have not, the deputy commissioner have not communicated to us, my lord, regarding this, my lord.
Kindly see paragraph 7 that with regard to paragraph 9 of the answer in deponent states that as informed by the deputy commissioner, Dhubri, a letter dated so-and-so along with our connected papers were received by the deputy commissioner Dhubri from the chief engineer so-and-so regarding requirement of fund for the work construction of so-and-so. Accordingly, the executive engineer was requested by the deputy commissioner to clarify the matter, but no response is yet received by the deputy commissioner Dhubri. Who is paying for the PWD? None. And what is the latest one? Show me.
Just one, my lord. 1/1/2022, the letter was issued by the superintendent engineer to the executive. And then, my lord, under secretary to the Government of Assam PWD, my lord, to the chief engineer. Asking, my lord, inviting a reference to the above, I am directed to return here with the demand proposal submitted by your letter under reference along with a copy of endorsement from judicial department and to request you to take necessary action for submission of demand proposal in the financial year 22-23.
Then
Then, my lord, no communication, my lord. with you. This is the communication that at my lord, 1st of April 2022.
your name?
M. Hussain, my lord.
Mr. M. Hussain submits that pursuant to the affidavit filed by the Revenue and Disaster Management Department, there has been certain developments which you would like to bring on record by filing an additional affidavit. Good stop. This court also finds it relevant to observe that the PWD department who had issued the work order to the petitioner and whose name has been duly reflected in the cause list have not appeared in the matter. Under such circumstances, this court fixes the matter again on when? Matter again on 30th of August 2023. In the meantime, the petitioner is given the liberty to bring on record by filing an additional affidavit. Mrs. P.R. Mohanto, appearing on behalf of the Revenue and Disaster Management, shall also apprise this court as regards any further development in the said matter.
Right.
Party in.
Now, in this case, the government has filed an affidavit. A copy has been supplied to me only a while ago. I'd like to file a reply to that affidavit.
Yes, what do you have to say? No, we'll look into it.
Madam.
You were supposed to file the affidavit bringing on record as regards the duplicate and triplicate case diary.
Madam.
What is your stand in your affidavit?
Well, in fact, the report was submitted, which we were directed to bring on record by filing the affidavit. Yesterday we filed it. I can just hand over a copy of the report for your copy from my court.
What does it say?
They basically say duplicate, triplicate copy could not be traced. And they are praying for 3 months' time to reconstruct at the end of the report.
This is an incident which happened in 85.
Yes.
And this matter has been pending from 2019.
Here.
Yeah. And again, even after doing all these things, you are still asking for another 3 months. Hmm?
Really?
Why do you want to file a reply?
My lord.
What is
this
there to
it.
file a reply on this? Because here he is asking for this. You just submit as to whether, you see, as of now, they say that we have not been able to find out the duplicate and triplicate. They are saying that although in 2019 there was an attempt to reconstruct the case diary, after extensions also they could not. So, and as such, they are asking that let there be a task force be appointed by this court for the purpose of reconstruction and giving them 3 months.
I can
Now,
understand.
there are 3 levels of officers which have been said. One is the DCP level officer from the Office of the Commissioner of Police. One is a person from the police station. One additional SP office / SP rank office from the CID. Now, what do you have to say on it?
Well, as per the Assam Police Manual,
Ah.
the case diaries are required to be maintained
Understood.
very under.
No, there is no
Efficient
denial to the
purpose.
fact. They are not denying that. They are not denying to, you see, now your only question is, or your concern out here is that the magistrate concern is not in a position to commit it to the sessions court,
Yes,
taking into account that there is no case diary. Earlier, there was an attempt being made for sending it to the, or it was committed without the case diary and it was returned back. So without the case diary, it cannot happen.
Not proceed. with.
So the basic idea for you out here would be how it can be constructed so that it can be committed without doing, but as of now, they have, from the fact finding or whatever maybe they have done, so they could not find these 2. So what is the alternative you have apart from this? We'll hear it again on
My lord, basic question is that.
16th of August.
can it
No,
be such
no,
thing
Mr.
considered?
Goswami, we'll hear you on this report on 16th, only to that. As to what other alternative,
Can it be on some other date, 17th? Let it be 15th on Tuesday.
15th you want to come?
15th, I'm not asking for 15th, my lord. It's my
We'll have it on 21st. On 21st.
23rd.
No.
21st. 20
Then we'll hold it, the petitioner is not intended to appear.
Let it
Otherwise, we
be,
don't
let
want
it
to
be
hear.
17th, my lord. According to his convenience.
17, no.
Well, let it
17
be
is
on
the
21st.
I have other matters.
My lord, 21st at 2 PM, my lord. No, my 21st, I'm not some day. Any day except 21st, any.
We'll have it on 16.
My lord,
Only to that effect. You only submit on this as to, do you have any other alternative but to this or any other officers should be there?
yes.
That is the only point, nothing
And
else.
this
Now
time-
we have no other alternative.
My lord. And this time.
And the
person-
person concerned who have done all these things, he's now 86 years old. So you can't catch hold of him now.
And he has approached after 35 years.
Understood? Because of the lapses on the part, they have been waiting what to do.
35 years. Man, this time this request has, Lord, will kindly see one thing, has come from the top officer. This time he himself has taken the entire matter and it is the principal secretary home. He himself has, my lord, supervised everything so that there is no lapses. And in the
Understood.
report.
So we may have to appoint a special task force.
My lord,
So you just argue on that, nothing
Yes.
more than that.
yes.
Okay. Mr. D. Mujumdar, the learned additional advocate general, has submitted that an affidavit has been filed in pursuance to the order dated 28/7/2023 today. Taking into account that the said affidavit would be required for further adjudication of the matter, list the matter again on 16th of August 2023, on which date the petition would be heard as regards the contents of the report enclosed to the affidavit.
Right.
List accordingly. Second slide.
Date.
14. Hmm. Where's the other side? What has happened? That it has been given to others for some other party?
Earlier occasion they appeared, today they.
No. Has it been that the dealership has been given to some other person?
Probably it was to the respondent number 3 law.
Respondent number 3.
3 law.
It has been given. And respondent number 3 is outside the area.
Lordship. That lordship, his document revealed that lordship.
Hmm?
The document which is annexed in the affidavit in opposition.
This is under this draw of lots,
No,
no? Group 1, group 2, group 3.
Preference, lordship, first preference should be given to the concerned Gaon Panchayat. Then lordship, if
No, there will be draw of lots, 3
Draw
draw
of
of lots. The first will be if persons are there in the residential area.
in that particular panchayat. Then
Yeah.
lordship, the
In fact, I have delivered a judgment on this point, exactly on this aspect.
lordship,
There, Mrs. Nirupama Saikia was appearing, and and this P. Bhardwaj was appearing for this. Where I have set aside that thing on the ground that those persons concerned were in from Guwahati, but on one day before the submission of the form, they have taken a lease.
Malum for that also Malum kindly press the affidavit in opposition lordship. That part will reflect. The last day of submission of lordship on 13. On 12, they have purchased the land lordship, and same day it was muted in their name lordship.
No, there is a Supreme Court judgment I have referred to.
Lordship, lordship.
You have a look at it. Yes. That judgment hidna disu na itu. What is the name? Nirupama Saikia. And there I have referred to. There, in fact, the Supreme Court also took into concern what is the residence.
Lordship, lordship.
Because here we are concerned with residence.
Only residence lordship.
And the Supreme Court says that even that was a case where a person was concerned, had a property on of the husband. No, that can't be. The basic reason for this is on the for the purpose of giving benefits to the residents who are there. And as such, residence has to be understood in that. I think that will help you.
Lordship.
So taking into account that the respondent number 1, 2, and 3 are not represented when the matter has been called for. This court, for the interest of justice, adjourns the matter. Mr. K. Gogoi, appearing on behalf of the petitioner, submits that there is urgency in the matter, taking into account that the respondent number 3, most illegally, have been allotted the, what is that?
Durgam Khetra Vitara LPG.
LPG distributorship.
Lordship.
Taking into account the above, list the matter again on 24th of August 2023, on which date an attempt shall be made to dispose of the matter. So it is made clear if the respondents are not represented on the next date, this court shall proceed with the disposal in their absence. 15. See that judgment, huh?
Lordship, I'm there.
Yes, Mr. Dhar.
My lord, the question here is to be decided
Hmm.
whether if the plots of land acquired in 2005 and compensation has not been paid for the major share of the land and not assessed will come under the new act of 2013. This is right to fair compensation act, because the land was acquired under the National Highways Act 1956. They occurred in 2005, but they have not assessed the amount. They have not paid any compensation. Only Zirat amount was reassessed. And then
So when was the award passed?
award was passed in 2005 itself. 2005.
Award was passed.
But no award was passed in that.
No award?
No, we have, in our affidavit, we have clearly said whatever compensation is assessed by competent land acquisition, National Highway already paid amount. This is under
Have
provision of-
you passed an award in terms of 3G?
Yes, we have.
Where is it?
That is our affidavit. Lordship will get our National Highway Authority. It is signed by one Sudhiranjan Bhattacharya on behalf of National 5 million. Lordship got it. Our affidavit.
Hmm.
Here we have clearly said, we annexed also. Here Lordship will get Muhammad 3G It was page 10.
You see, you have moved the arbitrator
Yes,
against what?
against the non-fixation of this land compensation.
How can you do that? Under 3G, you can approach the arbitrator when you are agreed with a particular amount.
Yes, my lord, the order is
Because national highway.
page 31 in 2014.
Where the land is acquired under this act, there shall be paid in a year, Iman, whether right of year. Before proceeding to determine the amount under subsection here, the commonwealth shall give a public notice published in two local newspapers, one of which will be shall state the particulars of land, shall require all persons interested to appear in person or by his agent, so and so, of the event before the competent authority at the time and place, and state the nature. If the amount determined by the under subsection 1 and is not acceptable, the amount shall on an application by either be determined by the arbitrator. Subject to the provisions of this arbitration. And when was the arbitrator appointed?
Arbitrate in appeal was order is at page 31. The order is dated 4 October 2014. And this form G, proforma form G under 3G is only for Zira, not for compensation. What my senior has pointed out, it's only for Zira. And I approached the arbitrator since the solatium and other benefits under the law, and as well as the compensation as well as access.
And then
Then the arbitrator order has not been acted upon. Then the petitioner approached this honorable court.
And this court directed that the arbitrator's award to be acted upon. Then
Then nothing has been done again. It was
you are saying that it has not attained finality. The award.
the award is only for Zira,
No, what is mean? There has been no finality.
no point, because
Unless it is not final 24(1)(a), you are referring to 24(1)(a),
yes,
wherein it says that if it is not been completed
yes,
and the award has not been passed, then the acquisition has compensation has to be as per the new act.
anyway. And even their own circular is there. I have annexed with my affidavit in reply.
Hmm.
That also says so. And in fact.
But this act was brought within the fold of the new act because this was otherwise not applicable
Yes,
to the new act, taking into account section 114 or something, and this was been brought within the fourth schedule.
fourth schedule.
So under such circumstances, after 1 year it was brought in. It was said that it was not applicable. So 2000, that was from 1/1/2014. That means from what date it has come into operation?
First of
1/1/2015.
first of
1/4, no,
January 2014.
14.
1st of January is for this act,
Yes,
2013.
39.
But for 1 year, there was an exception given to those acts which were there in Schedule 4. National Highway Authority Act is one of that. In view of section 100 and
Exception.
105. National Highway Authority is there in Schedule 4.
Yes,
National Highways Act 1956. So for 1 year,
that is 31st/12/2014. 31st/12.
that is why. So after 1 year, because here it says, subject to subsection 3, the provisions of this shall apply to the shall not apply to the enactments relating to land acquisition specified in fourth schedule.
Yes,
So in view of subsection 1 of section 105, this act was not made applicable to the National Highway Act. Now 3 says the central government shall by notification within 1 year from the date of commencement of this act, direct that any of the provisions of this act relating to determination in control in the first schedule and so, in the second or so being beneficial year shall apply to the cases of land acquisition under the enactments specified. So that is why that notification has come on 31st of December 2014, making it applicable from 1st.
Yes.
Yes. So that is how it happens. Now you are saying once it is applicable, the award has not, that there has been no determination till date.
Till date.
And as such, you are entitled to the determination as per the new act.
Yes, that is right. My lord, the main.
In view of 2411, 1A.
Yes. 24(1).
A.
A.
But whether 24(1A) would be applicable, taking into account that 24 is only in respect of land acquisition 1894.
That aspect was also there.
And that has been already
That-
held by the Supreme Court in the
Yes,
case of
yes.
Bangalore. That one, na? What is that? Bangalore Development Authority.
Yes.
That has been said where they wanted to bring section 24 to the Bangalore Development Authority. They said that you couldn't have brought it because this benefit is only being given in respect to acquisition which have been done under the Land Acquisition Act.
But it has been clarified by the Ministry of Rural and Transport by their own notification.
Show me.
I will kindly not will need to take my affidavit in reply. Filed on 29th of May.
Affidavit in reply.
Reply.
Dated
It's dated 20.
page, running page. What is this running page? On 29th of May.
Yes,
Yes, where is that notification?
notification starts internal page 12,
Huh?
internal page 12.
Yes. Land acquisition in man. I'm directed to say that the land acquired for national highway acquired under the provisions of section 3 pursuant to the enactment of Iman and Common for certain provisions of Iman have become irrelevant to other acts mentioned in it. The Ministry of Iman specified the people who have mentioned the outcome of non-intention has also become guidelines for different establishment. Being the monthly department of the for the youth is managed.
I'll take your lordship to page 15, internal page
Just
15.
let me have a look because there are so many other matters
Others.
also. I get enlightened with all this. May out of the ordinations and taking.
It is number 29, 5.
আমি নাকি আমি একটু কারা গেছে দিতে ঠিক বলেছে ঠিক বলেছে ঘুরে বলছে
Yes, which year? What are you referring?
My lord, internal page 15. 4.6 Roman 3.
Hmm.
By now, it is also settled proposition that the first, second, and third schedule of the RFCTLARR Act 2013 shall be applicable to the NHA 2056 with effect from 1/1/2015. As such, the following is clarified. A, all cases of land acquisition where the awards had not been announced under section 3G of the NH Act till 31st of December 2014, or where such awards had been announced, but compensation had not been paid in respect of majority of the land holdings under acquisition as on 31st/12/2014. The compensation would be payable in accordance with the first schedule of the Act of 2013. So now, my lord,
You are on this.
I'm on this, or part.
My lord, for instance of justice, this particular affidavit which your lordship is producing, it is reply against the deputy commissioner reply. That is not been served because if it is served also not, this one may be this one. This is not with me. But regarding this another compensation part already, my learned friend is saying that it has not been paid. My affidavit is clearly says land for land value we have given and for Jirat also we have paid.
Where?
That is my affidavit position.
Who are the petitioners here?
Here, my lord, page 10, my
What is
lord.
the name of the petitioners?
Hemendranath Deka, Rajendranath Deka, Korna Kanto Deka.
So you are saying about page 10, Annex 3.
Yes, my lord, that is page 10. Your lordship will get
Value of the land, value of the building,
value of the land, 3,50,000 and value of Jirat 66,728. It has been paid.
This was paid when?
When I have stated in my affidavit, it was on 2011, 2009, 2009 itself. One is 2012. Landowner by money receipt 2011, 2009, 2011 to and 25 for 2012.
Where?
Where I have stated in paragraph this page 4, my lord. Page 4.
See that it's Jirat compensation,
Jirat only, land and Jirat only will get it.
only Jirat.
Jirat, land also is there, value of land. Total 4,45,000.
So these payments were made of 95,000. Where is that 95,000? Total 21,42,000. Phase 1, phase 2, and phase 3. Jirat compensation paid. What is the Jirat compensation paid? How do you?
Jirat compensation means, my lord.
No, Mr. Borua, how do you reconcile Annexure 3 with paragraph number 4, the last portion of paragraph 4? How do you reconcile?
Which one, my lord? Paragraph 4.
Paragraph 4, the last portion at page 4, it said that the Jirat compensation paid first phase 95,000 on 25 to 12. Second phase, it goes other way. How can the third phase be first? What is all these things? The national highway.
No.
What is this?
That means we would have written first this one. But we would have written this way. Other way.
Other way. Okay, now, how do you reconcile this amount with this amount?
Which one?
Because here the total amount is 4,45,000.
Yes.
How do you reconcile that with, how many petitioners are here?
There are
Three petitioners.
three.
Name?
Hemendranath Deka, Rajendranath Deka,
And
Korna Kanto Deka.
So the total as per Annexure 3 is
yes.
only 4,45,000.
Actually, what happened, my lord?
Then?
Oh, yes. This because another page would have been also, we would have annexed. Yes. Now I'll bring record now.
You bring record or whatever may be, but this is not satisfactory.
That's it. I'll satisfy because that is a fact. My affidavit writing may
Your
be
affidavit
different.
is wrong.
No, my affidavit writing may be, but when
No,
they
your
pay-
affidavit in writing says that the amount paid to them is 21,42,000.
That is why other.
Whereas as per your annexure 3
No,
is
no,
only 4,45,000.
That is why record will be required, Milord. Record will say everything. I'll try to bring record and let him give me also affidavit reply also. I'll also go
Give
to
a
that.
copy.
That I'll.
We'll have it well.
My lord, just one thing I need to point out. The Union of India's affidavit may be wrong, but the affidavit filed by the deputy commissioner here.
Here, Kala is the main, of course, no doubt in that. We are
He is
paying.
the
to
Who is the
Kala.
competent authority?
Here is the
Yeah.
Now,
competent
let's see the
affidavit,
competent authority
Yes.
affidavit.
Page 3.
Page, annexure, affidavit filed
Affidavit
by
of
whom?
opposition by respondent number 3.
Okay, what does it say? Rahul Pathak.
Ratul
That with regard to the statements made in para 4 of the affidavit, the deponent begs to say that 4 bighas 2.9 was acquired for construction and even as per the notice to in the 4 bighas demand as per the 3G statement. Hemendranath Deka, so and so, total is 15 lakhs.
Then the next page, page
Out
3.
of the aforesaid land, the compensation has been paid to the awardee is 21 lakhs. So
So
Hemendranath Deka,
Hemennath Deka,
And 6 others.
Hemennath Deka, area of land 2 katha 12.5 lesa. This is the compensation for land. It was fixed at 2,10,000. The rest 3 are Zirat value.
Lordship may
Not to-
kindly compare it with the data stated in page
And
2.
The second paragraph clearly
Page-
says,
Page 2, Lordship, serial number 1, Hemendranath Deka, and 6 others, patta number 62, amount 2,10,000. Then next page, Hemendranath Deka, patta number 62, dag number 4, 2,10,000. It was paid. Then at page 2, serial number 2, Hemendranath Deka and 8 others, patta number 63, 3,50,000.
not paid.
The amount which is shown at page number 3 down below, that amount is not paid. 13,24,910, that was not paid. The reason is the awardee had not submitted any claim petition to receive the compensation. That is our affidavit.
did you issue notice? Asking them.
Lordship.
Now, did you issue notice that kindly come out here if you have any objections and all? Have you come?
No.
If you have not done, then what is this?
Lordship.
3G says
Not-
that.
Out of
Very
that,
good.
out
Now
of
we
that
have
50,
Mr.
the
H.
sum
Sharma
amount,
also.
no, Lordship.
Will also aid in the education very well. We'll put your name out there.
Lordship, that out of
Okay.
15,34,910, 2 lakhs and
From a
odd, 2
perusal
lakhs
of the
10,000.
affidavit in opposition filed by the respondent number 5, and more particularly paragraph number 4,
Lord.
and upon being reconciled with annexure 3 of the said affidavit,
Lordship.
it apparently shows discrepancy. The issue, the case of the petitioner as submitted is that the petitioners were paid certain Zirat amount, but the compensation in respect of the land was not paid. It is under such circumstances that the petitioner has approached the arbitrator. And the arbitrator directed the deputy commissioner, the competent authority, to take note of arbitrator White award dated
4th of October 2014.
4th of October 2014, directed the competent authority to take note of the compensation as regards the land. Pursuant thereto, nothing has been done. And no compensation has been paid thereupon. Although there is also a direction by this court for payment of for determination of the compensation to be payable in respect and determination of the compensation in terms with the arbitrator's award The learned counsel appearing on behalf of the petitioner further draws the attention to the communication dated 23/12/2017 issued by the Joint Secretary to the Government of India, Ministry of Road Transport and Highways, and in that regard had made specific reference to clause 4.6 Roman 3A. Full stop. Mr. C. Borua, appearing on behalf of the National Highway Authority, submits that he needs to take instruction as regards the discrepancy in the affidavit. And also submits that he is not aware of the communication dated 23/12/2017 enclosed to the affidavit in reply. Full stop. This court, upon hearing the matter, finds it relevant that the records pertaining to the competition, determination of the compensation by the petition, by the competent authority, would be required. So, taking into account the above, this court fixes the matter again on 29th of August 2023. On which date, who is going to produce it?
I'll produce regarding TG, whatever documents I have, whatever, but he has to pay.
The competent authority, the respondents that is the deputy commissioner, which one? Who is the competent authority?
Kala. See, Mr.
What is this color business?
ADC.
Competent authority,
Competent authority for land acquisition.
Additional deputy
Competent
commissioner.
authority.
Additional deputy commissioner?
ADC, maybe ADC
Come,
because.
competent authority.
Where?
Kamrup Metro.
The additional deputy commissioner Kamrup Metro, as well as the National Highway Authority, shall produce the record in respect to the acquisition of the petitioner's land.
Lordship is fixing it on 29.
I may be served copy.
16 and 17.
Yes, tell me.
It is one consent slaney, not.
After 2017 to 2020, it has come for the first time today.
So,
And we have to file reply. After filing of affidavit in opposition, it has come for the first time. So it takes some time to file a reply.
so doesn't the Guwahati High Court rule say the affidavit in your position is filed, you have to file your reply within 7 days? If you want. Do you need an order for that? Tell me. Why don't you put it out there somewhere that the rules, Guwahati High Court rules needs to be amended? Okay, you take 6 months, we vacate the interim order. What do you say?
No, Lord.
No, we vacate the interim order. What do you say? Isn't it, Mr. Chaudhary?
My lord, why pursuant to interim orders, my lord, as many as 7 retail outlets are running for years, my lord. The matter needs to be heard first, my lord.
This matter needs to be heard because you have put him in the holiday scheme.
Yes, my lord.
If you have put them in the holiday scheme, this court, because of the fact that there is a dispute between him and him.
Yes.
There's another matter, same, no?
Yes, both the
That,
matters.
no, that I had made it part heard, then I released it, remember?
Yes.
You were there.
Lordship,
You are also there.
Yes.
Yes, you are involved in all these holiday scheme matters.
That, my lord.
That what has happened to that matter? That
one
is a
matter that has been
2015-16
that has been
matter.
withdrawn, my lord. If
Huh?
I'm correct, my lord, that was Makub Motors.
Ah,
That was Makub, that has been withdrawn.
Matu Motors is withdrawn. And what Lordship was hearing was another method.
which was that?
That some method.
Ah, so these are, he was there. So these are matters where holiday scheme, there is a fight between them. You see, you have no other way.
We don't have any choice, my lord.
Choice. That is the policy. So we can't give you, because of you, now you are earning
Yes.
Yes.
on the basis of an interim order. He is being affected. Are you paying him something?
Lordship, what has happened, I'll tell you. Lordship.
Now you know. So no problem. We can hear it. Tell me.
No, we need to file a reply, but I know the facts, Lordship.
No, I also know the fact. Tell me. Nothing is there.
Lordship,
They have no other option. If they tried and gave you a lot of opportunity to resolve your disputes,
Yeah.
nothing is being done. What to do?
in two,
On the in the earlier matter also, I gave you a lot of opportunities to resolve it. That has not been done.
in
Since
2006 and 2009, Lordship, there was a
2016,
settlement.
my lord, because of the anti-murders, my lord, yeah.
And you are only earning.
Lordship will fix the spot, Lordship, by then we file a reply, Lordship.
You need to submit your accounts also. Because you are earning. And to his prejudice, how will he know how much is the amount?
Yes, Lordship.
Tell me.
But in 2006 and 2009, we had entered into a settlement. As per the settlement, she has her share and we have our share. Lordship. Now, after 5 years, she files a civil suit challenging the memorandum of partition. Now fails to obtain an injunction order. Now, when she fails to obtain an injunction order, she files a complaint to the IOCL for reconstitution of the matter.
So there is a civil suit.
Yes, Lordship, 73/2014.
What is the status of that?
Lordship, it is pending, but there is no injunction order.
Injunction is not there, but what is the status?
Lordship,
What is the case for? What is the case, Mr. Goel?
My lord, this is the case.
the
that-
plaint is in the reply of IOCL 103. Lordship.
My lord, in that case, because so many properties are in Gorakhpur also, and we are not, because my lord, this is dealership, not ownership, your lordship. What we have claimed before the learned court below is the over which the petrol pump has been situated, my land. That is under challenge before
So
the
you are asking for partition.
partition of the land, your lordship.
It's a partition suit.
No, Lordship will
That
see the
title-
plaint at page 103 of
That I have
the
annexed, my lord.
reply of oil.
Page, your lordship.
No. Where's the plaint?
Plaint, Lordship,
Page
103 of the reply of oil. Lordship.
I have filed, my lord, 103 type copies there.
Where?
In my affidavit in opposition. your lordship.
What is this, the fat one?
No, it's a affidavit in
Whose
opposition of
petition is this?
My learned friend.
What? This one, Sharma and Co.
Sarma, 8433.
8433
My
is
lord,
whose?
8433, I have filed affidavit in opposition.
This affidavit in opposition.
No, my.
No, Lordship,
That is
in
the clear
in
petition.
item number 16,
This is whose is 8433?
This is
You are there.
Sharma and Co, Lordship, initially I was appearing there, Lordship, but item number.
Now you are not appearing in 8433.
No, I am appearing in 9468, Lordship.
Who is appearing for 8433? None appears. So
Similar relief,
very
my
good.
lord, when they have got-
It is a repetition.
my lord, they have not got
Placing
any
us
relief
to in the
8433,
holidays.
my lord. They approach, they file another petition.
Lordship would
Understood. Wait. 8433, none appears, so we dismissed for default.
Manan.
The names have been shown.
He was a-
They are challenging a letter dated 10/6/2019, bearing reference number along with so and so. Maintain the status quo as regards the sale and supply of high street. Now, this is the same order being passed in the other one.
Yes.
But
No, my lord, so
why
far-
there are two petitions?
No, my lord, so far this order 10/6/2019 is concerned, my lord. That is prior to an order of this honorable court in my lord other requisition. And in fact, my lord, this relief has become infructuous in view of the order of this honorable court, which your lordship will find that page 351. Because your lordship will
of-
see,
This one.
yes, my lord.
350.
This order, my lord, 10/6/2019 is a decision of the IOC to put them on a holiday list. Thereafter, my lord, 10/6/2019 is the order. Then, my lord, on 12/9/2019, this honorable court passed an order. The order starts at page 351, relevant 369.
Why has Manan so and so in all these petitions, common question of law are involved
359.
in dispute regarding this court most of the holiday introduced by the IOCL in terms of the leave granted by expansion postponed the hearing of this batch of petitions. Referring to the scheme introduced by the administrator, submit the holiday again that offering an opportunity to pay bail benefit and to resolve the dispute between them for government to continue that however fail to take advantage of that, then it would be up to the authority to take appropriate. Today's client must be given the liberty to attain any decision on the annual authorities, including holidays exercise, without submission on the conflict of time operation between people. In public statement, they mention that he had no effect in their submission. No something all parties. So here, there was a liberty being granted to the petitioner to again approach,
Yes, my lord.
subject to dispose of as infractions by granting leave to the parties to approach this court again if so advised in the event there is a fresh cause of action in the matter.
Right.
So therefore, they file pursuant to this, they file this writ petition.
Yes, my lord.
Now, this writ petition, the order which has been challenged is the order impugned letters dated 10/6/2019, as well as the letter dated 12/6/2019.
My lord. These are prior,
These are orders being passed.
prior to this order.
Prior to the present impugned order.
Huh? No. There are two orders. Na? This is pursuant to, these orders were passed prior to this order
My lord.
of Justice Shyam.
Right.
So nothing remains,
Yes.
isn't it?
Yes, there is a order of justice.
So in view of this order, this writ petition has no value because what you are challenging has already been taken care of, and you were given the opportunity to assail if you are aggrieved to, because you wanted out there what to do. By referring to so and so, Mr. Manan submits that his clients may be given the liberty to assail any decision of the IOCL authorities, including holiday scheme, if so advised. It is also the submission of Mr. Manan that until such a time a proper decision is taken as per the holiday scheme, status quo as on today be maintained as regards the dealership. Now, pursuant to that, there must have been some order passed,
Yes.
which you have challenged out
Yes.
here in the second room, where you are there.
Yes.
Isn't it? Chalo.
Here, your lordship will kindly see the prayer.
We close this.
Yes, my lord.
এখন লেখক হা, WPC number 8433/2019.
But our challenge to the putting us in under the holiday scheme is still subsist, Lordship. But yes, Lordship, correct. We have subsist.
These orders have already been taken care of, na? Because subsequent thereto there is an order passed,
Yes.
where you are putting it challenge.
Yes.
The instant writ petition has been filed. The instant writ petition is filed by the petitioners challenging the letters dated 10/6/2019 bearing reference number TDO/RS/MM-Jaipur JEYPORE/199 TDO/RS/MM, Digboi/200 and TDO/RS B.N.Singh/198, along with the letter dated 12/6/2019 bearing reference number IOCL/SDO/Sharma and CO/02 issued by the Indian Oil Corporation Limited, and for a further direction that the petitioner, that the respondent authorities to allow the petitioner to continue and run the retail outlets of the high-speed diesel, motor spirit, and super kerosene oil. This court have also perused that pursuant to those orders being passed, there is an order dated 12/9/2019 passed in a batch of writ petitions. That is WPC number 7454/2017, WPC number 7509/2017, WPC number 7458/2017, and WPC number 7456/2017. Come on. From a perusal of the said order dated 12/9/2019, it reveals that the council appearing on behalf of the IOCL had submitted that the holiday scheme was aimed at offering an opportunity to the contesting parties to avail the benefit thereunder and resolve the dispute amongst them so as to permit the IOCL to continue with the dealership. So, the Learned Counsel for the IOCL further submitted in the said proceedings that if both the parties fail to take advantage of the same, then it would be open for the IOCL authorities to take appropriate action in the matter as may be permissible under law. It is further seen that the counsel appearing on behalf of the petitioner in those petitions had also submitted that his clients must be given the liberty to assail any decision of the IOCL authorities, including the holiday scheme, if so advised, until such time a proper decision is taken as per the terms of the holiday scheme, status quo be maintained as regards the dealerships. This court, by the said order taking into account the consensus arrived, disposed of all the writ petitions as infructuous by granting leave to the parties to approach this court again, if so advised, in the event there is a fresh cause of action. Taking into account the above order, it is further relevant to take note of that pursuant to the said order dated 12/9/2019, an order has been issued on 20/11/2019 bearing reference number IOCL/SDO/Sharma and Co/11 by the IOCL authorities. The said order is the subject matter of challenge in WPC number 9468/2019. It further reveals that in the said proceedings, there is an order dated 28/1/2020 passed by this court, whereby the respondent IOCL Limited, the respondent numbers were directed not to give effect to the communication dated 20/11/2019 until further orders and allow the petitioners to run the dealership outlet and SKO agency until further orders. Taking into account that pursuant to the said order dated 12/9/2019 passed by this court in the above mentioned writ petitions, there has been already an order being passed on 20/11/2019, which is the subject matter of WPC number 9468/2019. This court is of the view that the writ petition being WPC number 8433/2019 has become infructuous. Accordingly, the said writ petition stands closed as infructuous. Eto hoi gol. To file to gusai joti.
Lordship, just one thing, Lordship, in the earlier order, liberty was given to challenge the letters also, the holiday scheme also, but in the present petition, the holiday scheme is not challenged. Therefore, Lordship, liberty may just.
Why should I give you liberty? You already have the liberty. There was a challenge only to those two, and to direct them to allow you to hear. Now there is pursuant to that, the order there you must have submitted something And in pursuant to that, they have rejected it. And against that, you have already challenged this.
Yes.
And as such, and you have also got an order to that effect.
Yes.
So what remains? You are not challenging the holiday scheme, that is good. And if the holiday scheme goes, IOCL will be more happy.
Yes, we can just
The
have-
thread on which you hang is gone. That is why you have not challenged it.
In this case also, my lord, the subsequent case also, they have not challenged the holiday.
Obviously, the moment they challenge, the trade is gone.
Yes.
It is on because of the holiday scheme, you are allowing them to have it something.
Yes, my lord. so
And
many
pursuant to
technical-
that, as the period is over, you have stated, taken action.
Fine.
Chalo, now let us have this matter. Tell me, what do you want to do? You want to file an affidavit?
Yes, reply.
Who against whom?
Lot of IOCL, but because.
Only respond number 1, 2, 3, and 5 has filed. You have not filed.
In fact, I have filed in another. It was that your lordship had disposed it. So I will file my same affidavit. In that affidavit I have written, my lord, it will cover present matter.
Oh, that matter is gone.
So that I will file. Tomorrow itself.
Mr. BP Bora, appearing on behalf of the petitioner, submits that the petitioner would like to file an affidavit against the affidavit in reply to the affidavit in opposition filed by the respondent number 2, 3, and 5, dated
My lord, it was filed in December 2020.
18th of December 2020. Mr. A. Goel, appearing on behalf of the respondent numbers. Who? 4 and 5, 4. Respondent number 4 submits that he requires an accommodation of a week
Fine.
to file the affidavit in opposition. Taking into account the above, Mr. M.K. Chaudhary, the learned senior counsel representing the respondent numbers 2 and 3
2, 3, and 5.
and 5, submits that the writ petition was filed, that there is an interim order operating against the respondents' authorities. And the affidavit in opposition was filed on 18th of December 2020. He submitted that on one hand, the petitioner is enjoying an interim order, and on the other hand, have not filed any affidavit in reply in the meantime. And the petitioner is delaying the disposal of the writ petition. So, taking into account the above, this court fixes the matter on 31st of August.
May I brief for some cost?
Huh?
Cost.
Not today. On 31st August.
On second year or before 31st or after.
29th of August. On 29th of August, the petitioner is directed to file their affidavit in reply by 21st of August 2023. The respondent number 4 is directed to file their affidavit in opposition by 17th of August 2023. And the petitioner, if so advised, may file their reply by 25th of August 2023. The instant writ petition shall be taken up for final disposal on 29th of August.
Highly obvious.
18.
Please, your lordship. In this matter, senior advocate K.K. Mahanta sir, but today he is not available. Therefore, my lord, kindly agenda matter.
Why?
My lord, my senior is not appear today, my lord.
So, you have a good case. Why you are not doing it by yourself? Huh? Why you are not doing it yourself? Yes, GMC. How many times he is going to file a suit? He has already got a suit. First, you demolish it at his request. Then he puts some garbage out there. He gets a suit. Suit decreed. He removes. again, now he is again constructed over his land. He has also gone to the particular deputy commissioner for demarcation. Demarcation has been done. Then also why you are not taking action?
I think that part of.
Demarcation has been done or not?
Done.
Done. Then why you are not taking
Removal
action?
has been done, my lord. The demarcation part removal has been done. There is allegation.
No, removal has not been done.
So
After demarcation, I
why
have
you are not doing it?
represented.
That's it. What else is there? And he's asking his senior to come. Yes.
In the event, my lord, Lordship will turn to page number 16, there is a representation pending that will act upon it. my lord.
Yes, do it. Matter ends 15th. Representation dated
Dated 24/7/19.
19.
24/7/19, and there has been further reply petitioner approach by later dated so and so, as well as also submitted reply on 4/2/2020. So you act upon that within 15 days. If he has got the demarcation done.
No.
Act upon it.
As per the law, will proceed, ma'am.
As per the law, you proceed.
I am for the respondent number.
Yes, what do you have to say? Why you are constructing on his land?
No.
You are not constructing if there is a demarcation out there.
No demarcation in my land.
My lord,
Demarcation
regarding
as per order of this honorable court, in
Demarcate the
respect of the
boundaries
share
of
of the
the
petitioner,
issuing notice
in
upon
respect of the share of the petition,
Huh?
share of the petitioner.
Because
There are
the
as many as
direction
six
issued a
patadar,
direction
six
upon it.
patadar. Only one patadar has filed the application.
Now, whether the demarcation has been done or not,
I am
done,
not
my
aware.
lord. Kindly have a
Totally,
look
we
at
are
this.
not aware when demarcation is if demarcation was made in respect of his share,
That is
it
15,
is
my lord.
internal demarcation.
15.
15.
15 vernacular certificate, my lord.
1/5, yes. Jariya provision. Is that where Latmandal had demarcated the share of the so and
Yeah.
so? Yes, so and so after measuring all the four boundaries and yeah. So it has been done on 13/6/2016, 19,
No notice was served.
whatever may be, demarcation has been done.
In
You
respect
take
of
action.
share, what is his share?
You want to go and file civil suit, whatever may be.
No,
But you can't do all these things.
civil suit-
Demarcation, where is the question of constructing on his land?
No.
Demarcation has been done, whatever may be. And you know, when did you receive the notice? When did you receive the notice?
No.
Notice of this case?
Affidavit in opposition I have filed.
When?
Your lordship will see, it was filed on
16/8/22.
yes. 16/8/2022.
You do one thing, the best option is,
The
Let-
civil- Another case is.
no, nothing doing, Mr. Council, nothing doing. We do one thing, the commissioner, revenue is there, deputy commissioner is there. Let us do one thing.
Nepal.
You take action as per the representation, means as per accordance of law, in consultation with the circle officer.
No, my lord, here-
Because circle officer says,
here-
I'll ask the circle, direct the circle officer also to do the needful.
No, my lord,
And if necessary, one person would be sent for that purpose.
no, my lord, I have made some submission. Here,
We have no
my lord,
submissions.
It is the third litigation. Earlier, two litigation,
Earlier, they broke your place.
my lord.
Earlier, they have demolished.
No, they have not.
They have demolished.
Only they.
And then you kept the garbage on the
Immediately,
road. How many
1987.
times a person will work? Go and keep on
1987,
filing suit after suit and suit? This is the
my
third.
lord, 1987, the demolition was done. Immediately, I made the construction. And they said that there will be no further demolition. In the suit, I filed the suit against the GMC, and GMC said in the suit that there will be no further demolition.
Then you withdraw.
No, this suit was dismissed because the apprehension, my apprehension was they made.
So why didn't you get a
further
compromise decree done?
My lord,
You could have done a compromise decree.
not a compromise decree, my lord.
You could have gone, if they are saying that they are not going to do it, then obviously there should be a compromise
So
decree for
here,
that.
disputed
But
question
the
of
suit being dismissed means your cause of action was not there.
Anyhow, my lord, thereafter,
Anyways,
thereafter, they filed the suit. They filed the suit. The brother of the petitioner filed the suit for permanent injunction. And that suit was decreed. Yes, that suit was decreed, restraining us not to prevent them from removing the garbage. Here is a boundary wall, a Pakka boundary wall. It was constructed in 1962. The Pakka boundary wall in between the land of the petitioner and my land. There is no dispute. There is a finding that there is no dispute in regard to the land. There is a finding of the civil court.
okay, the instant writ petition
lord.
has been filed.
So, my lord,
Mr.
mandamus lie.
Mr. Upadhyay,
Mandamus does not lie.
okay, you make that submission before the division bench. Okay.
My
The
lord.
instant writ petition has been filed. Seeking a direction upon the respondent authorities, more particularly the GMC, more particularly the Guwahati Municipal Corporation. Now, the instant writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the Commissioner, Guwahati Municipal Corporation, as well as the Chief Executive Officer, Guwahati Metropolitan Development Authority, on the ground that the representations so submitted on 24/7/2019 and 2/8/2019 respectively have not been considered by the said authorities, even after the demarcation of the land of the petitioner by the officials of the Land Revenue Department. It is further the case of the petitioners that on 4/2/2020, the petitioners have also submitted another reminder to the Commissioner GMC for taking necessary action, but nothing has been done by the respondent authority, respondent number one. This court have duly perused the representations so submitted by the petitioner on 24/7/2019, 2/8/2019, as well as on 4/2/2020 to the respondent number 1 and 2. It further reveals from the records that the Guwahati Municipal Corporation had filed an affidavit in opposition through the Joint Commissioner of Guwahati Municipal Corporation on 19th of October 2020. 19th of October 2020. In the said affidavit, it was mentioned that the demolition, as stated in paragraph number 3, was done almost 33 years back, and subsequently, if any construction was made in the Pakka land of the petitioner, then the same may be demolished by the petitioner himself. Further to that, it was mentioned that since the demarcation of the land has already been done by the Land Revenue Department, therefore it is open to the petitioner to clean his plot of land from all or any type of physical structures at his own cost and risk and not by the public authority. To the said affidavit in reply, affidavit in opposition filed by the GMC, an affidavit in reply was filed stating inter alia that the GMC authorities have powers under section 337 of the Guwahati Municipal Corporation Act 1971, 69 or 71?
71.
71. To remove to demolish when such constructions are contravenes the provisions of the act and the bylaws. It further reveals that the private respondents, that is respondent number 6, 7, 8, and 9 had also filed an affidavit in opposition wherein it was mentioned that there was a demolition made 33 years back. And thereupon the petitioners have, the respondent, private respondents have duly constructed the land, building,
Not building, my lord. That is sanitary latrine.
had constructed the sanitary,
No, only sanitary latrine was demolished. Only sanitary latrine.
had
was
demolished. You constructed thereafter what? You have not
Sanitary
constructed.
Sanitary latrine. Sanitary latrine was demolished.
And-
That was found unhygienic at the time, and it was demolished. Thereafter, immediately in 1987, I constructed.
Another sanitary.
Building was constructed in 1960.
What is 67? What did you construct?
Not 67, 60. Building was constructed 1962.
No. What was demolished was the sanitary.
Sanitary tank.
Sanitary tank was demolished.
Yes.
Then what did you do thereafter?
Immediately I constructed.
What did you construct after that?
Sanitary.
So you
Let-
constructed another sanitary tank.
Yes, exactly.
That is what I'm asking you.
Exactly.
কি লিখলে তো? 33 years back to the sanitary tank, and thereupon the private respondent had constructed the sanitary tank in their own land.
Yes.
It was further mentioned that the respondent authorities, that is the GMC, even as well as even the revenue authorities, have no jurisdiction to decide on the question of title. Inasmuch as if the petitioner is disputing any right over any portion of the land, the petitioner has to approach the civil court. Isn't it here?
The other thing is also here. Basically that.
It seems that it is further appears that the petitioner herein had also filed a reply to the said affidavit in opposition filed by the private respondent number 6, 7, 8, and 9. 6, 7, 8, and 9. 67 or 87? 87, na? It was demolished in 1987.
87.
87 days, 67 not. It further reveals that on 30/1/2023, an affidavit in opposition was, additional affidavit was filed by the petitioner. Wherein an incident relating to the civil Nazir entering the petitioner's boundary, petitioner's land, have been mentioned. To the same additional affidavit, certain photographs have been enclosed to show that the demarcated boundary pillars were demolished by the civil Nazir.
Ashok, my lord. Yeah. Ashok Bhattacharya removed, my lord, not civil Nazir. Ashok Bhattacharya removed. He was directed by the learned trial court to remove the illegally constructed.
He says, na, that is his allegation.
Yes.
I am not saying you.
Yes.
What have you filed a reply against
Yes,
this?
yes, reply is there.
You have filed a reply against
Reply,
this?
yes,
When? Oh, yeah, another reply.
yes. Reply
So there is an
20
execution
20
proceedings also.
Yes, execution proceeding is pending.
In execution case number, as regards
There
your,
is the order, my lord.
now you
Earlier-
have filed some suit.
Earlier, by misleading the court, the Ashok Bhattacharya, his brother of the petitioner, got issued the writ. And got the land demarcated. And pillar was erected in my land. and court found that the writ was wrongly issued.
My lord,
So
that was
court
defined from my land.
directed to
That
re-
was defined from my land.
Hmm?
The petitioner land and Kastu Patas's land are different.
Chalo.
Execution is in different part.
Okay, I'll come back at 2 past the remaining. But you see, my direction will be to the GMC only if there is no disputes. If there is a dispute, the GMC is not going to do anything. I'm making it vague. Then you have to go to the civil court.
They actually in the, yes.
Okay, they shall file the application within 30 days
30 days. Yeah.
with a certified copy of the order.
And one more, I'm extremely sorry, madam. Item number 6. Now at 2 p.m. Lordship picked the matter.
Item number?
6, madam. Since my friend P. Sharma was the advocate, madam, he has already been expert. Now I've been instructed to take the time so that I can enter the case, madam.
Which one? Item?
6 of today's. So I have not been entered. Only today I have been instructed to get
Item number 6 is which item?
of today's list. Usha. Usha. And probably I have come to know government has filed the affidavit today.
What is the matter about?
My lord, I do not know anything. I do
You don't know, you have not entered, so why should I hear you?
Wetlands, well, they're occupying, the stand of the government is they're occupying wetlands and that is impermissible.
Oh, that is the Nagaon one.
Yes, ma'am.
The Nagaon one, Kolong Park.
My lord.
Your specific stand is that they cannot.
They cannot be allotted with these lands on account of the embargo in clause 14.6 in the land policy 2019, my lord. It says
They cannot be, but you have to do something as regards these people. Where will they go? You have to also take note of and give them allotment in proper areas then. That is what, obviously, no allotment can be given if it is, because your stand out there in the affidavit is that if they are allowed to reside there, it will lead to clogging of the river
environmental damage.
and environmental damage. So you have to take a call on that, rehabilitate them in some other place by apply. They'll let them apply for make application, and then you need to dispose. I think that is the best you can get, nothing more than that, without even knowing the facts. Yes. We'll take it up after some time. Let me complete my dictation in this matter. Last line to लिख ले. Where the demarcated boundary pillars which were erected were uprooted by the civil Nazir. First, to the said affidavit in reply, so filed, additional affidavit so filed. The respondent number 6, 7, 8, and 9 had filed an affidavit in reply, stating inter alia that the land of the respondent number 6, 7, 8, and 9 are situated adjacent to the western boundary of the land of the petitioner and his brother, and the land and the said land of the respondent number 6, 7, 8, and 9 is higher than the land of the petitioners and his brother. And there is a Pakka boundary wall in the western boundary of the petitioner and his brother since 1962. And there is no land dispute in between the petitioner and the respondent number 6, 7, 8, and 9. It was further mentioned that in title suit number 197 of 2001, filed by the brothers of the petitioner and others for permanent injunction to restrain the respondent number 6, 7, 8, and 9 for creating obstruction in clearing and removing the debris and the wall leaning against their houses. The permanent injunction was granted as prayed for by the judgment and decree dated 19/1/2004, passed in the said title suit, and the execution case was filed by the brother of the petitioner, Sri Ashok Bhattacharjee, and he got the writ for execution of the decree dated 19/1/2004 by misleading the court, and 5 Pakka boundary walls were erected by the decree holder inside the land of the answering of the respondent numbers 6, 7, 8, and 9, which was beyond the scope of the decree. And the matter was brought to the notice of the executing court by filing a petition. It was further stated that the executing court directed the decree holder, Sri Ashok Bhattacharjee, to remove the 5 Pakka pillars at their own cost, and he was also directed to pay exemplary cost of rupees 10,000 for taking wrong steps of the writ, and also for misleading the officer of the court via the order dated 21/6/2019 passed by the Munsif number 1, Learned Munsif number 1, Kamrup Metro, Guwahati, entitled execution case number 4/2014. Further to that, it was also been mentioned that the said order dated 21/6/2019 was also upheld by this court in CRP IO number 272/2019. It was further mentioned that the contents of the affidavit, additional affidavit, as well as the FIR so filed, are baseless and not sustainable. It is further seen from a perusal of the affidavit in reply that the sanitary tank and the cantilever alleged to have been constructed on the petitioner's land is within the land of the respondent number 6, 7, 8, and 9. And beyond the sanitary tank and the cantilever, there exists a Pakka boundary wall on the west from the share of the land of the brother of the petitioner, Sri Ashok Bhattacharjee. From the above pleadings, it transpires, therefore, that there are serious disputes as to whether the sanitary tank as well as the cantilever exist is constructed on the land of the petitioner or is within the boundary of the respondent number 6, 7, 8, and 9. First. It is further relevant to take note of that from a perusal of the writ petition, it is the clear and categorical case of the petitioner that pursuant to the demarcation so made by the circle officer, by the concerned circle officer, whereby pillars were erected, the petitioner had submitted certain representations to the respondent number 1 and 2. It is on account of the inaction on the part of the respondent number 1 and 2 to take any action, took any steps pursuant to the said representations. The petitioner has approached this court. This court is of the opinion that the representations so submitted by the petitioner needs to be addressed by the respondent number 1 and 2 by giving an opportunity of hearing to the petitioner as well as the respondent number 6, 7, and 8. The respondent number 1, that is the commissioner of the GMC, is therefore directed to take a call on the representations so submitted by the petitioner within
Hearing has to be done, my lord.
within
Within this month.
Huh?
Within this month, my lord.
within 13th of September 2023. 13th September.
Yes.
By giving an opportunity of hearing to both the petitioner as well as the respondent number 6, 7, and 8, and 9. This court further observes that the commissioner of JMC, while deciding the said dispute, shall also duly take note of that if there are serious disputes pertaining to the land between the petitioner and the respondent number 6, 7, and 8, and 9, it shall only be the civil court who can decide the same. However, if there is any violation to the building bylaws or to the provisions of, if there is a violation to the provisions of the Guwahati Municipal Corporation Act 1971 or the building bylaws, the Commissioner GMC shall take appropriate action as deemed fit. A copy of the instant order the registry is directed to serve a copy of this instant order to Mr. S. Bora, appearing on behalf of the respondent number 1 for effective compliance. With the above observations and directions, petition stands disposed. Yes, Mr. Chetri.
Timing item number 6.
Can we take it some other day, my lord, since I have found something else, my lord, in the affidavit, my lord. Whatever they say that in the DAG number 301, has been, tag number 301 is shown as unclassified government wetland. And in the remarks column is mentioned as Kolong Nodi in para 3. Though I'm not an advocate, my lord, in the case. But
Taking into account the stand. Taking into account the stand so taken by the respondent number 3 in its affidavit dated 22nd of April 2021, that the land wherein the petitioners are in occupation, how many petitioners?
I do not know. But,
The petitioners are in occupation are
11.
Hmm?
11, my lord.
The petitioners are in occupation are
para 3 is very clear.
wetlands.
My lord, whatever tag number they have shown, my lord, petitioners are not residing in the tag number, my lord. They are saying that in tag number 301, it's a wetland, but petitioners are not in the particular tag number.
Question of fact. Then.
As per the para 3, my lord, paras lordship will find everything. This contradictory view they have taken. So some other day lordship will take up the matter.
Taking into account the stand taken by the respondent number 3 in the affidavit in opposition, as well as also taking into account the notice impugned in the instant proceedings, that there are various people illegally occupying the water reserves of Kolong, Mori Kolong, and what is that? P-O-R-A, Pora Kolong or Porat Kolong? What is the name? And Puta Kolong. The respondent number 3, the revenue department of the respondent number 2 is directed to apprise this court as to whether the lands in question can be settled with the petitioner, and if not, whether any alternative lands can be allotted to the petitioner for settlement, allotted to the petitioner for their rehabilitation. List the matter again on 30th of August 2023 for obtaining necessary instructions, for the instructions as sought for. Number 10. Yes, what instructions you got?
Instructions is, my lord, DAG 46 is government land, my lord. And they are sitting on it. And not only on DAG 46, also on 56. They are sitting on it. Apart from the Miadi.
Oh, he's saying that 76 which have been allotted, the DAG number 76 which have been given to him,
My lord.
is carved out from DAG number 46, which is however not apparent from the papers.
Also comes to page 11, the right hand side. There's an application for making the land Miadi Patta land here also. And acting on that, the land in question was Miadi Patta land here also.
Okay, their stand is that you are entitled to, they are not going to take anything upon you as regards the land which have been settled. But apart from that, any other land you will be thrown out.
Yes, also.
You are okay with it?
337, tag number 337, which is in my possession.
No, you are, how much is the land which has been given to you?
4 बीघा, 2 कथा, 10 lakh.
Huh?
4 बीघा, 2 कथा, 10 lakh.
So here, madam, your stand, if you kindly see at paragraph number 4. The respondent number 2 denies the claim made in para 9 as per the report of the circle officer Dhemaji. The petitioner have encroached upon more land than recorded in the name. The eviction notice was served against the excess land occupied in Dag number and not against the Miadi land of the petitioner. Therefore, this notice shall only be acted upon in respect to any land beyond the Miadi land.
Yes,
That's all.
my lord.
A simple thing.
That will be your.
The instant writ petition has been filed challenging the notice dated 9/4/2018 issued under number D.J.C.15/B E. G. J.C.C.15/B.
BE.
Bear. No, if you see D, B, bear.
Oh, Bay the hall actually.
Bear.
DJ.
Bay the hall, you just
15.
put Bay the hall. Bay the hall oblique 2018. Full stop. Issued by the circle officer Dhemaji.
There is another number here also on the right side, 253 dated, oblique 253,
Oblique types of 2018 oblique 253.
dated 9/4/18.
That I have given. The facts of the instant case, as could be discerned from the affidavit, from the writ petition, is that the petitioner that a plot of land measuring
4 bigha, 2 katha 10 lecha.
4 biga 2 katha 10 lecha covered by Dag number 337 of Patta number 76. Of village Momari, lot number 6. Shows that the petitioner is the owner of a plot of land measuring so and so, covered by Dag number so and so of village Momari, lot number 6. Under within Moza Dhemaji, within the district of Dhemaji. This aspect of the matter can be seen from Annexure A to the writ petition. It is the case of the petitioner that the said land so settled, the land of the petitioner was initially a part of Dag number 46 of the which was the government land. But subsequent to the conversion, the petitioner had been granted the Hiraj Miadi Patta of the aforementioned land. It is the further case of the petitioner that on 9/4/2018, a notice was issued by the Circle Officer Dhemaji stating inter alia that the petitioner was illegally occupying government land by raising wall in dark number 46. And the petitioner was directed to remove all his movable and immovable properties as per the said notice. The said notice has been challenged by the petitioner on the ground that the respondent authorities, and more particularly the Circle Officer Dhemaji, is taking steps to evict the petitioner from his settled land. It appears from the records that on 23/4/2018, this court issued notice and further directed that the petitioner shall not be evicted from the land measuring 4 bighas 2 katha 10 lechas in patta number. Is it patta number?
Patta number is 76. Your Lordship.
76.
Covered by in patta number 76.
Dark number 337.
And if the boundary wall is constructed over the said plot of land, the same shall not be demolished. The matter, the writ petition has been pending since then. Today, when the matter has been taken up, Ms. S. Sharma, appearing on behalf of the
2 and 3.
respondent number 2 and 3, have placed before this court an instruction issued to her by the Deputy Commissioner, District Commissioner Dhemaji. It has been mentioned, categorically mentioned in the said instructions, that the petitioner have encroached upon more land than recorded in their name. There or his, in his name. It was further mentioned that the eviction notice was served against the excess land occupied in dark number 46 and not against the Miadi land of the petitioners. It was further mentioned that a petitioner was issued Miadi Patta number 76 against dark number 337 under village Momat. Momari or Momat? Huh? Momari. But the petitioner is unlawfully occupying land in dark number 46 and 56. Apart from their Miadi land of the same village. The said instructions so submitted during the course of the hearing by the learned counsel appearing for the respondent number 2 and 3 is kept on record and marked with the letter X. This court have duly heard the learned counsels for the parties. From a perusal of the materials on record, that it transpires that the petitioner has rights over a plot of land measuring 4 bighas 2 katha 10 lechas, covered by dark number 337 of patta number 76. Of village Mumari under Muza, lot number 6 under Muza, Dhemaji, in the district of Dhemaji. Under such circumstances, the petitioner has no right, therefore, to be in possession of any other land other than the land above mentioned. Taking into account the specific stand taken by the District Commissioner Dhemaji to the effect that the respondent authorities shall not disturb the possession of the petitioner in respect of the Miadi land, which has been settled in the, which belongs to the petitioner. But their action is against the illegal occupation of the petitioner in respect to other lands. This court disposes of the incident with petition. With a direction upon the respondent authorities and more particularly the respondent number 2 and 3, not to disturb the petitioner's possession in respect to the land measuring 4 biga 2 katha 10 lechas covered by DAG number 337 of
Number 76.
Pata number 76 under village so and so. It is made clear that the respondent authorities shall be at liberty to take such course of action as per the provisions of law to evict the petitioner in respect of other land other than the land mentioned to any other land in DAG number 55, 46 and 56 other than the land belonging to the petitioner. The above the petition stands disposed. RT3. Itu? Itu one with no, they wanted an adjournment. No, this will be taken in due course. Local.
Let me seek your lordship's indulgence. My lord, item 11, the deputy commissioner is seeking time for Jai. They've not been able to lay their hands on the land acquisition case, my lord, the record. They have written to me, my lord, I have it with me.
Which one? Ramotesh Chandra Roy.
Yes, my lord.
You are asking some? You have not received a single penny?
My lord.
Are you sure?
Yes.
The affidavit says otherwise, my lord.
Some of them, my lord, with petitioner, some of them, my lord, received. And my lord, out of them, my lord, I have a list. My lord, they have not received. My lord. That's why, my lord, on the last occasion, this honorable court, my lord, categorically stated, my lord, asking them to file affidavit, my lord, showing the name of the beneficiaries to whom the amount has been paid and who has not been paid. That, my lord, affidavit,
My lord,
they
if
were
I may
supposed
say-
to give.
If I may say, my lord, lordship directs production of record in original on a date fixed next.
Wait, first, let us see how much court fee he has paid.
My lord, we have paid additional right now, my lord.
You have paid?
Yes, sir.
Fantastic. Something goes to the
As
government.
you have lordship said, my lord, I have immediately paid.
Ms. S. Sharma, the learned counsel appearing on behalf of the respondent number
Respondent number 4, 5,
No,
Five.
you don't appear for 4. You appearing for 5 and 6.
5 and 6, my lord. 5, 6 and 7, my lord.
5, 6 and 7. And Mr. A. Bhattacharya appearing on behalf of the respondent number 4. 6 for an accommodation of a week for the purpose of apprising this court for the purpose of obtaining the instructions as to whether any award has been passed in the instant proceedings. Have been passed in respect to the land acquisition proceedings. The learned counsel for the petitioner submits that BK Sen, Mr. BK Sen, the learned counsel for the petitioner submits that some of the petitioners have not received a single penny. On the other hand, it is the stand of the respondents that the petitioners have received some amount. Taking into account the above, this court therefore directs whom? Whom should we direct?
The deputy commissioner to produce the record in original.
The deputy commissioner, come district collector, Hosai,
No, this
Nagaon,
should be ADC in charge Hosai.
to the direct the ADC, additional
ADC
district commissioner. Is additional district commissioner.
Yes.
Hosai,
In charge Hosai.
in charge Hosai. To produce the records of LA case number
One
of 2017.
1 of 2017. On the next date fixed. The said officials shall also ensure that in the records, the list of beneficiaries as well as beneficiaries is there. List the matter again on how much?
10 days.
Okay, list the matter again on 25th of August.
Deeply obliged.
Can it be 26 million, 25 million, I will be out of state.
26 you come only to the court. On 25 let him come. 26 is closed.
19. 27 million.
27 is more closed, Sunday.
I'm off.
Yes, who is there? What is this matter? That one, same, high tech. We'll have it on 22nd. This is the matter on 22nd of August 2023 along with WPC number
3002 of 2021.
same
Lordship, 28 is also same.
one.
28 and 19.
And
19 and 28.
19 and 28.
28.
Wait, just 1 minute, sir. Just 1 minute, 1 minute. Yes, oh, not this one. This is another matter, na?
Item number
28, sir.
20 is Lordship different.
Huh?
20 is different.
20 is different.
Yes.
20 is what?
20 is Lordship relating to interest.
No. 28 to some. Let's see 28. Yes, 28, tell me. 28, the order is by this court. Accordingly, in the meantime, it is directed that respondent number 2, Commissioner Central shall dispose of the representation submitted by the petitioner, including one dated for the fixation of special rate within 4 weeks from the date of the certificate. It is also directed that till the such decision is not taken, so and so will be there. Then what decision has been taken?
In Barakola, this case, the decision has not been taken.
Are you saying that the decision? Who is appearing for this? Where is Mr. Kyle?
Lordship, my senior is on legs in court number.
Okay, we'll take both of them together. Time like A2 22nd of Thagir. Item number 19 to 28, we'll take it up after some time. Item 22.
May I please, your Lordship. In this case, Lordship, the question is that, Lordship, that my Lordship, earlier the refund was not granted to me. Because Lordship, what had happened that in a central excise, Lordship, the notification which was issued, the policy and notification, the exemption has to be given for a period of 10 years. They gave me for 7 years, Lordship, we came before this honorable court. This honorable court granted for another 3 years. So they refunded me back the money. Now the question is, Lordship, the levy, the interest. They have not provided me with the interest. Lordship, from the date of Lordship deposit to the, they have given me interest only from the date after the judgment was passed, we gave them a letter that the judgment is passed, you give us the refund. So they delayed in giving that. So they gave us interest only for 3 months. Now the moot question before this honorable court is that from when the interest has to be calculated, whether it is from the date of payment of my duty, from when they should have refunded it to me, or from the date of judgment of this honorable court. That is the question, Lordship. Lordship,
So they initially gave you an exemption for 7 years.
7 years.
You challenged it.
I challenged.
And this court stated, no, you are entitled for 10 years.
10 years.
And therefore, those refunds which were there,
For 3
you are
years.
now claiming from that 99.
99. I got those Lordship refunds they have given me.
Understood?
But now I am claiming for the interest on the refund. Lordship, now, Lordship, there are judgments of Lordship C-State. There is a judgment of Supreme Court which I am referring to, and there is a judgment of Lordship Meghalaya High Court also on the basis of the C-State judgment. Lordship, if I may be permitted to.
Yes, what is it?
Lordship, in the seat.
You will do one thing, ask them to file the affidavit. You are there? Yes, what is your stand? Very good.
We have not yet filed our affidavit, Your Lordship.
Understood, but this is of 2020. Then you're taking advantage that there cannot be an interest on interest. Is it something like that?
Lordship,
Is it?
Yes.
Okay, when? 2020, you have not passed and done anything?
on 10 days time.
Okay. Miss so-and-so appearing on behalf of the GST department seeks for an accommodation for 10 days for filing the affidavit. First to list the matter again on 30th of August. The affidavit be filed by 25th of August.
Much okay.
21.
Maybe.
Mr. Dekar, this court has already issued rule in this matter. Why is this matter come up? Isn't it?
My lord.
The issue is as regards whether town.
Correct. And a
Can-
few more issues, and
Huh?
that is the moot issue.
Will have fixed it for hearing on a particular date.
The only prayer is, that pertains to a proceeding of 1976. In fact, it's the second round. So,
Understood. We'll fix it on a date which is convenient to you. You are a busy counsel. Then, in that the order. I passed an order to the effect.
yes, ma'am. That was on 11/2/22.
Yes, 11.2. The instant repetition involves an important question of law which requires adjudication as regards the applicability of Assam fixation of ceiling on Land Holdings Act 1956 to the area in question in as much as the area has been declared as town. So you say, being a town, you can apply this.
Because eventually, whatever is surplus, that has to be acquired and settled for agriculture. As per land policies, town land cannot be settled for agriculture. So the basic object behind the act or the acquisition will not be available.
So are you saying that the fixation of Land Ceiling Act doesn't apply to town lands?
My lord.
It's mentioned somewhere.
My lord,
The act doesn't say so.
act defines land, my lord, under 3A. It says what is used or may be used for agriculture. Now, whatever is ceiling surplus has to be disposed of in terms of 15 and 16. Now, section 15 and 16 is saying that that will be available for settlement for agricultural purpose. Now, my lord, there are judgments.
Now, whether this particular land
My lord.
in the revenue records is what?
My lord, there are several dags, my lord. Some of the dags have been classified as Noba, which would be Bosteel land. My lord,
And-
in fact, I'm also.
But the village? Village,
My lord.
then
My lord,
where is the land?
Sila Sinduri Gopal. Amingaon.
Ah, there. So, these are all village.
My lord, in fact, I'm also alleging differential treatment because on that very same ground, my lord, ceiling proceedings had been dropped in respect of other.
But when did the Sila Sindhu Gopa
It
become
was
a town?
declared way back in 66. my lord.
It was declared as a town.
Yes.
So it would, you say that the 1976 Act ought to have been applied, not the 56.
My lord, 56 Act cannot be.
So 76 would have been. But the 76 has been now taken.
No, it was a one-time measure, so it's gone.
So it is no longer there.
In fact, my lord, other irregularities are also writ large, my lord. In fact, your final statement was never published, my lord. Retention was never specified. And in fact, a dead man's name figured in the possession, handing over of possession. My lord, first of all, my lord, the final statement was never published.
7, not done.
Not done. In fact, the revenue authorities admitted that certain anomalies are there, but they say it is too late in the day to review it.
Now they have settled the land with somebody.
No, they
No.
have not said it is still in my possession.
Fantastic. We'll have it on
Not an early
19th of September.
date. Can it be earlier?
You want it early? Okay, tomorrow? Or no, today, 5:30? Yes. I'll make it more early. Taking into account the order passed by this court on 11/2/2022, whereby rule has been issued. This court fixes this matter on 12th of September 2023 for final disposal. Liberty is given to the petitioner to mention the matter for upgrade. 22.
So in the morning, I paid for an accommodation lordship.
Hmm?
I paid for an accommodation lordship.
I know. Now tell me what is the case. You went to, you are challenging an order. Thereafter that order, you have challenged in appeal. Why you are here? No CGAT.
Without opportunity of.
Where does it apply? Appeal?
Lordship, here is also affidavit not filed, your lordship.
Madam, government, how will government run on your thing? They just stay or no stay?
No stay, lordship.
Hello.
Sometime, your lordship.
No interim relief granted. Ms. So-and-so, the learned counsel appearing on behalf of the GST seeks for an accommodation for filing affidavit in opposition. 6 weeks' time is granted for that.
Okay.
23. Yes,
May please lord.
you are challenging, no confidence.
Lordship.
So why?
But the section 15, my lord, has not been complied with. And my lord, from the notice also, my lord, the record will reveal, my lord.
Huh?
The record will reveal, my lord, whether it was, my lord.
The records produced, Mr. Devnath.
Within 3 days or beyond.
Better
3 days.
notice, what is the notice business see? Section 15. Was he issued the notice?
Yes, my lord. And it was sought to be served, but this, the petitioner had refused.
Meeting of notice, my lord. Second notice, my lord.
Hello.
By the Ansalik
What is
Panchayat. Ansalik Panchayat, sir.
You can do.
It was referred on 12, my lord, within 15 days. Second,
Let me see the record, or we set aside. Yes, where's the notice? Deputy Commissioner, parawise comments, nothing doing, no confidence to Bokta Ali Secretary against Kulbur Rahman President. This was done on 28/12/2020. Grounds for no confidence, many grounds. How many persons? 1, 2, 3, 4, 5, 6, 7. Copy to Kulbur President. Then, what is this? What is this in Assamese? What are you going to read it? When did he receive? Peon book, 61 pages went to Kulbur Rahman. Date so and so, no confidence motion against Kulbur Rahman, so and so. Peon.
12 of
Who received this? Mazbar Rahman, who is that?
He's the secretary, my lord.
Huh?
He's the secretary. Mokhtar Rahman.
When did you receive it?
It was not placed before the, my lord, petition.
At any point of time?
Lordship. And second notice, my lord, of meeting, that was also not served.
Regarding the no confidence motion against Swens, who issued? The secretary. I have the honor to inform you that on demand 7 numbers of members. This is
It was
being
placed
given by
before the
the
secretary.
president to Mandir Anchalik Panchayat Mandolia. Your Gaon Panchayat.
Lordship.
And from the engineer to convene a meeting within 15 days, but could not hold any meeting till 18 months. So it should on when? 28/12. And 12/1, 28/12, when did you get, when was it served?
Just what we served by the peon, my lord, but they refused to accept.
When?
It's mentioned, the date is mentioned of that.
Mention is not there. On being received the petition, the same was forwarded to the petitioner by a notary in Myanmar. Filed for the same along with the original copy dated on 29/12, which the petitioner had flatly denied refused to receive. The same dated in money in presence of witnesses went. So he refused.
Yes, sir.
You send it on 12/12, 29/12. So 29/12 is the date. We need 15 clear days. What is the 15 clear days will be? You can't take the date. Clear days thereafter.
From 30 onwards.
30, 31,
13.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 you have issued.
13.
13,
12
It's 14 days?
14.
Or how many days?
12 plus 2, my lord, within
Huh?
14 days.
So what is the time? 15?
15, man.
So
Within 15 days. It's supposed to be.
From the 28, my lord.
28, what is 28?
20th of
No,
December.
they themselves said that it was sent on 29th.
Even 28 is counted, my lord, then 15.
Not 28, 29. It is there, admitted stand out there, it is 28. And it says 15 clear days. So you can't take that first date. So in between that, it has to be within this period. So that is the 15 clear days is not there. Is it there?
It's the 14 days that
No, would 14 days be enough?
it's supposed to be 15, my lord, but it says within 15 days. It's supposed to be.
No. 15 clear days.
In case, my lord, it says, my lord, in case a meeting is not convened within a period of 15 days from the date of receipt or notice, the secretary of the government shall within 3 days.
Within
But
15 clear days?
the exact words over here, my lord, this one. It says such a meeting is not convened within a period of 15 days from the date of receipt of notice.
But if we count from the 28th of December, so
28, no.
29.
It can't 28. You can't do 28. 28, it is admitted on 29th only the peon book.
29, 30, 31, 3 days and 11 days. Then 14 days.
In
And
case
within
such a
that-
meeting is not
and 12
convened
it was
in the
referred to
period of
15 days.
15 days from the date of receipt of the notice,
One.
the secretary of the Gaon Panchayat shall within 3 days refer the matter to the president of the union, who shall convene the meeting within 7 days from the. Somewhere I read it clear days somewhere. What is this clear days? So within 15 days from the date of the intimation, would it be 29 be taken into account?
It's not supposed to be.
Eh?
It is not supposed to be, it's supposed to be from 30th. But fact remains, my lord, it says over within 15 days if there is no decision.
Mr.
meeting is not
Bednar,
convened.
kindly come here. I know he is the main person out here who will be losing if he loses. But you are the main person to address this call.
That was over here, my lord, that the meeting is, if the meeting is not convened, we have period of 15 days from the date of receipt of notice. And the petitioner has refused.
On 29. Then
They sent it on the 14th day, my lord, if it actually don't count 29.
on 12th.
My lord.
So can it be sent on 12th?
After refusal, my lord, is there any need to wait actually 15 days? My question is this, my lord. After the petitioner has clearly refused to accept the notice, so there's no.
There's one judgment, I think.
Yes.
There's some judgment on this point.
Yes,
I think by Justice Mehdi. Is there a judgment that if a person refuses to accept, then it is not required? No. Secretary cannot refer the matter to the president.
Yes, my lord, there's the judgment, Ranjit Singh.
15 days from the date of definition. Oh, no, there's one judge. Wait, which paragraph you are referring to?
My lord, para 9, my lord.
Subsection 1 of 22 requires the Secretary of the Council.
Yes, there was no problem. On pipeline, critical effect. From the date of no facility for notice. Date of receipt, no. 29. This is safely for. No, but the. This is the issue of collecting. Okay. Yeah, look at Katana.
No, here it does not say. Now, what is your stand as regards this? That you have not received?
Yes, my lord.
The peon book the peon did not come to you?
No, my lord. I have clearly stated, my lord, it was not never served, my lord. And regarding 15 days, my lord, there is a division bench order, my lord.
Okay, you have filed your affidavit.
Lord, I have to file.
So you are accepting what he says? Huh?
I'm relying on records.
No, you are not, you are accepting. Because from 2000, it has been going on. Why haven't you filed your affidavit?
Paragraph 7 and 8.
Huh?
And all these excluded, my by.
No, this is mandatory. I'm not on that. There's no
Even
quarrel
all
on
these
this. No,
excluded. one.
neither Mr. Devnath is disputing this proposition. But one thing, however, it is there, just for example, if you refuse, then what happens? I think there is some few judgments on that.
In
If
this
you
also the-
refuse, not refuse to take, but if you refuse that I am not going to hold it, then you need not wait for 15 days. But the fact that this particular document was never placed before you is your admitted stand. And they've not filed the affidavit. So we go on the doctrine of non-traverse and allow, set aside whatever has been done.
Well, any procedural mistake by the
What?
secretary. Well, the secretary, it is the procedural mistake of the secretary, well, because the member submitted the requisition before the secretary of the government side. And it is the duty of the secretary to place the requisition first time before the president. And if president is not held the meeting, then refer to the Anchalik Panchayat. So due to the mistake of procedural mistake of the secretary, my lord, but member will not be suffered, my lord. So
Remember, that is why
it may be sent for fresh meeting, my lord. If he has confidence, my lord,
There's
then
no
so many
stay.
judgment, my lord.
now who is running it?
And my friend also taken another plea, vice president, my lord.
So
My learned, another plea is there, that he has not received any my lord, notice.
Hmm.
And then my lord, today he's came to learn in the judgment in another judgment also in the honorable court, my lord. The same plea was the president that I did not receive any notice from the member or secretary. Then the honorable take the plea that from today you came to learn that you have got the notice. So within 15 days you arrange the meeting. That was the
no,
judgment.
that I have done in many cases.
Yes, ma'am. So I am praying, madam, if the honorable court please.
You are
then
appealing
make
for
send
whom?
for respondent number, madam, 7 to 13, madam.
Seven to
Fresh meeting,
Members are-
fresh meeting may be held, madam. Members, madam.
members of after the vote against.
And what we need to set aside?
The resolution, my lord, is 22, madam.
Hmm?
Is 22 resolution.
22,
Then accept three.
and you have no objection for setting aside.
Well,
I will not say that.
And
You won't say that, but I will go on the basis of this. But the fact that, because one thing I have to take note of, that as he has now the notice says on today,
yes,
let it be, he will either convene or the secretary will take action after 15 days.
yes, ma'am.
From today is what date?
Nine.
Today, 9. We'll have 15 days will be how much? 9, 10, 11, 12. How many? You count, I'm coming in 5 minutes.
24.
Okay,
On
you
the
count.
24th. 24.
On the 24th.
The resolution dated 16/1/2021, adopted in the special meeting held on 16/1/2021, expressing no confidence against the petitioner. Now the deputy commissioner has passed an order thereafter.
Is that it was the executive officer one. Annexure 4,
Nectar.
in the petition man.
No.
This is forwarded to the executive officer.
An executive officer forwarded to the chief executive officer. Then what happened? As well as the communication issued by the executive officer, Mandia Anchalik Panchayat, to the chief executive officer, Borpeta Jilla Parishad, dated 16/1/2021. It has been submitted by the by Mr. N.K. Devnath, the learned counsel appearing on behalf of the responding Panchayat and Rural Development Department. That pursuant to the order, pursuant to the communication dated 6/1/2021, the petitioner has been removed and the Vice President of 66 number Chatola Gaon Panchayat is presently discharging the functions of the president. The facts involved in the instant case is that on 28/12/2020, seven members of the 66 number Chatola Gaon Panchayat had issued a communication to the secretary of the said Gaon Panchayat expressing their no confidence upon the petitioner, who was the president of the said Gaon Panchayat. It further reveals from the record that on 12/1/2021, the secretary of the Gaon Panchayat in question have issued a communication to the president of the executive officer, Mandir Anchalik Panchayat, Mandia, stating inter alia that the president, that is the petitioner, had failed to convene the special meeting within 15 days. And as such, the said communication was being forwarded for necessary action. Thereupon, a meeting of no confidence motion was held on 16/1/2021, whereby seven numbers of members present in the said meeting voted by secret ballot their no confidence upon the petitioner. It further reveals that pursuant thereto, the executive officer Mandia Anchalik Panchayat issued a communication to the chief executive officer Borpeta Jila Parishad on 16/1/2021 itself, thereby forwarding the no confidence motion and minutes of the meeting of dated 16/1/2021, as well as also drawing the attention to the said authority that the petitioner, who was the president of the Gaon Panchayat, had lost confidence of the Gaon Panchayat members by a majority of 2/3 of the total number of members of the Gaon Panchayat. The petitioner, on coming to learn about the no confidence motion so adopted on 16/1/2021, as well as the executive communication issued by the executive officer Mandia Anchalik Panchayat to the chief executive officer Borpeta Jila Parishad, had approached this court challenging the no confidence motion the resolution adopted in the no confidence motion dated 16/1/2021, as well as the communication dated 16/1/2021 issued by the executive member, Mondia Anchalik Panchayat, and also sought for a interim order that the Deputy Commissioner Borpeta should not act upon the said resolution. It reveals from the records that this court had only issued notice on 8/2/2021, but there was no interim order passed. Mr. N.K. Devnath, the learned standing counsel for the PNRD, as already stated here in above, had stated that as there was no interim order passed, the Deputy Commissioner Borpeta had removed the petitioner, and presently the Vice President of the Gram Panchayat in Cochin is discharging the functions of the President of the Gram Panchayat. The learned counsel, standing counsel, further during the course of the hearing produced the records from the records so produced. It reveals that on 28/12/2020, the notice was issued to the Secretary of the Gram Panchayat expressing no confidence by 7 members. The record further reveals that on 29/12/2021, an attempt was made to serve the said notice upon the petitioner, and the petitioner refused. Thereupon, on 12/1/2021, the Secretary has issued the communication to the President of the executive member of the Mandir. This executive member of the Mandir. Mandir Anchalik Panchayat Mandia. And thereupon, the meeting was called on 16/1/2021, wherein the no confidence motion was passed against the petitioner. The question therefore arises as to whether the mandate under Section 15 of the Assam Panchayat Act 1994 was duly complied with. Taking into account that it was only on 29th, the petitioner categorically submits, had stated in the petition on affidavit that there was no attempt to serve the notice upon the petitioner. Be that as it may, it is relevant to take note of that even assuming that on 29/12/2021, an attempt was made to serve it upon the petitioner and the petitioner had refused, 15 days period thereafter would be on 13/1/2021. Under such circumstances, issuance of the notice, issuance of the communication dated 12/1/2021 by the Secretary amounts to an infraction to the provisions of Section 15(1) of the Assam Panchayat Act 1994. This court had in various judgments have opined that the provisions of Section 15 are mandatory in nature, and as such, taking into account that there has been an infraction to section 15, this court has no other option but to set aside the meeting held on 16/1/2021, whereby the no confidence motion was expressed against the petitioner, as well as also the subsequent actions so taken on the basis thereof. Accordingly, this court therefore sets aside the meeting resolution so adopted in the meeting dated 16/1/2021 and the communication dated 16/1/2021 issued by the executive officer of Mandya, this Anchalik Panchayat, as well as also the subsequent actions so taken by the Deputy Commissioner Borpeta, thereby removing the petitioner from the post of the president. Next. This court, however, also is of the opinion that taking into account that the petitioner now has knowledge that there is a notice of no confidence being issued on 28/12/2020. The petitioner is therefore permitted, given the liberty to convene the meeting of the Gaon Panchayat in terms with section 15 of the Assam Panchayat Act 1994 within a period of, within
25th.
within 25th of on or before 25/8/2023. So it is made clear, if the petitioner does not convene the said meeting, the secretary of the Gaon Panchayat shall be at liberty to take, shall, in accordance with the provisions of section 15, take appropriate steps. With above observations and directions, the instant petition accordingly stands disposed. The record so produced by Mr. N.K. Devdutt is returned.
My lord has stated that the petitioner is given a liberty to appeal conviction. My request is that my lord, could it be is directed to appeal?
No. I am giving him liberty. He may or may not. If he does not, then the secretary will take. That is why the liberty. Otherwise, wouldn't I be saying that you have to hold it? Then what will happen otherwise? If he does not, the things will often. Now, if just for example, if he does not, if I direct him, if he does not, then what happens?
Then my lord, the secretary will take the necessary steps as per the secretary.
This is the same. If he does not, his chances are more bright.
But petitioner may be reinstated, my lord, that of the.
What line neta likhi bhai tu set aside pili kolu na. In that view of the matter, the petitioner is reinstated to the post of the president of the 66 so and so Gaon Panchayat.
24.
Yes, what is this? No affidavit. Why?
Lordship,
The matter has to come up in order, Lordship. Kindly see the order dated 10/2/2021, Lordship. As per that order, they have to submit their reply.
Lordship, grant us 6 weeks of time, we'll file our affidavit in opposition.
You are appealing for?
CGC SK Medhi. SK, for all respondents
Yes,
on behalf of CGC.
The council appearing on behalf of the respondents. Have no. The respondents, in spite of the order dated 10/2/2021, have not filed their affidavit. the council appearing on behalf of the respondent six an accommodation for 6 weeks for filing their affidavit in opposition. Taking into account the above, this matter again on 20th of September 2023. The affidavit in reply the affidavit in opposition be filed by the 20th of September, be filed by 15th of September 2023. Interim order passed earlier shall continue till then.
25.
Obliged.
Yes, Mr. Khan.
My lord, the state of Meghalaya, my lord, they were to file an affidavit for which time was granted to them.
Your issue out here is as to whether the chief judicial magistrate can transfer a proceedings to outside the jurisdiction, isn't it?
That is one, my lord.
That is the moon into it. If he can't, then all other things goes. What they had done, the chief judicial magistrate from here transferred it to Nongpu. Nongpu submitted a charge sheet out there saying that it is an accident case. It should have been a murder case, as per you. So it was shown as an accident case, and therefore you have approached this court. So the question therefore is as to whether the chief judicial magistrate of Kamrup could have transferred outside the jurisdiction.
Yes, my lord, that is the main question, and my lord, along with that, my lord, the entire case, my lord, the way it has been carried out, my lord, the police at Assam and the police at Meghalaya, my lord, they have not even examined the complainant who is the father of the deceased. And my lord, the facts and circumstances shows, my lord, how the police and the accused, they have acted hand in glove with each other, and how they have converted this murder case into an accident case, my lord. Only the statement of the driver have been recorded in the entire investigation.
All these things will be taken, but the first and primary issue is
Yes, my lord.
because once it comes back here, it's better. Because now the thing is, where did the offense happen?
According to me at Palasbari, Assam.
And for them it is Nongpu.
Nompo.
Okay. Now the police at Nongpu is doing all these things.
My lord, the police at Assam and police at Nompo, we have allegation against both. We have made party, the officers, we have made party. And
Have
we
they
have
filed
also-
affidavits?
They have not filed.
Someone filed respond number 3.
3 is by the DGP.
Huh?
On behalf of the DGP Assam.
Yes. Yes, Mr. Taluka kindly apprised this court as to whether the chief judicial magistrate would have the power to transfer this. It cannot. Because if he has the power, in fact, that day I was taking up another matter, which is again coming up on 11. I have serious doubts. Means the submission was made taking into Mazithir's judgment as to whether an investigation which is being carried out in Bokaro, in that case, can be transferred out here because the entire cause of action has happened here. But can this court do? Or is it the Supreme Court who can? Now, the power which has been exercised by the Chief Judicial Magistrate, in my opinion, I don't know, subject to what you say, it's too much. He couldn't have exercised and thereby transfer the process here from here to but he could have said that no cause of action is a reason I won't exercise anything. That's everything.
That much yesterday will not be
But
on there.
how can he say that I'm transferring it to Nongpu? That to outside his jurisdiction?
When it was brought to his notice that the accident took place inside Meghalaya, then probably he exceeded matter. That part.
If he had happened in Meghalaya, he could have dismissed the complaint, do whatever he did. It is another aspect of the matter. But could he have transferred the case to Nongpu?
On his own.
On his own. In fact, I have serious doubt as to whether this court under 226 can do it even to Nongpu. I'd have understood if it is within the jurisdiction of this court. If it is in Arunachal, this court can do it. But can this court do it in respect to Meghalaya? Because now Meghalaya High Court is there.
He could have stopped there But he had exceeded the other point.
Who is appearing for the CGM? No, not the CGM, but who is otherwise you are appearing for the police.
Police.
Police is okay, but but who is otherwise appearing? Who is going to protect the order of the CGM? I think the
think
PP
the-
needs to be brought in.
High Court Counsel.
Yes, who is the High Court counsel? There's no High Court counsel.
Probably notice was whether you can have. Last one.
Huh?
I'm told that. Huh? Okay.
High Court.
High Court, there are some counsel, my lord, TJ Mohanta and UK Nair.
Their names have been shown.
No, they probably they were not served with a copy, maybe. I
They are
cannot.
not a party here.
High Court is not a party.
My lord, what happened, my lord? We don't have that order of the magistrate is not with us. It is only by way of communication, which is at Annexure 7, page 60. We have come to know that the magistrate have done it.
What is the case number?
183, initially it was 183.
Palasbari, my lord, it is written there, my lord, subject. Palasbari PS case number 183 of 14.
So the magistrate will pass order where?
In Palasbari PS case number 183 of 14. And then the entire record will go to Nompo. We tried to search there, but we could not get it. We got only the case record of the Nompo magistrates case.
So how do we know that this was done by magistrate? Except this thing.
This is the superintendent of police who have, except this thing, my lord, I'll show, my lord. That I will show, my lord.
No, they will know because they have issued that order. Mr. BJ Talukdar, kindly see, you are appearing for the police. Now this superintendent of police, Kamrup, has done it. So if he has done it, he must have had the order or
Must
copy of
be.
the order.
He must be having that.
Then you produce that order.
I'll do that next. I'll do that. In the meantime, for the power magistrate, probably lordship may issue notice on the High Court.
Why should I issue notice on the High Court? High Court they've not done it, okay. But whether the High Court counsel was appearing here?
No, my lord.
No, they were not a party. Okay, that's fine.
My lord, page 89, annexure 19 also, my lord. Action taken report, page 89.
No, this is serious. Who is Mr. A. Borpuzari? Yes, you are appearing for whom? Who are they?
Home Department and
Huh?
Meghalaya.
I will file your affidavit.
will file, your lord. How its time may be granted.
Why haven't you filed?
Your lordship, actually, the advocate of General of Meghalaya will be appearing and I'll file.
So, does he, for that he is appearing, you are not going to file.
I'll file, your lord.
You made the same submission on the last occasion
Your
also.
Lord.
Then,
I'll file within 1 week.
okay, we fix it again. No, we are not concerned with what the other people say. I'm only concerned on the question of the jurisdiction or the propriety of the judicial magistrate to transfer this case from here to Nongpo. Very serious thing. You get hold of TJ Mohantok Matabuli course. Find them or TJ Mohant or anybody. We'll keep it, pass the order. TJ Mohant or anybody from the High Court. So get hold of a good criminal law. Anybody can find Mr. Jiaul Kamar also. That is better. He being weak, I can appoint him as an amicus. Yes, next.
26.
Obviously, my lord, this case has been wrongly listed because on the last occasion on 23/7, this honorable court directed us to produce the record.
Which one?
26, my lord, item
My
56.
lord, here we have challenged, my lord, page 62, my lord.
So here he is asking for his compensation.
I know, yes, but lordship, the honorable court wanted us to produce record.
Record, what is there to
pertaining
record? You,
the,
see, this is being done under 357A as to whether he is entitled to, what has happened, that criminal trial, what has happened?
Accused was convicted, my lord.
Huh?
Accused was convicted.
Convicted. Then on what basis do you get it?
My lord, 357A, my
So
lord.
what does he say?
My lord, 357A, there is a notification also, my lord, and the DLS.
What does 357A say? It is only on the question of rehabilitation.
Rehabilitation.
So the question of, it can't be 5 lakhs.
Yes, but
It has to be decided on the basis by the authority concerned.
but there is a notification, my lord, issued by the government, my lord, fixing the quantum, my lord.
Show me that. Because your another 4 matters are pending. You have not got that orders, na?
Yes, my lord.
Those orders I have kept it out there because of today this matter is there.
Yes.
The reason is that earlier, if a crime is committed out there
Yes.
and there has been, this person has been removed, there's no, there has been no conviction, you are entitled to on the ground that the crime has been committed. You know. Now kindly see 357,
My lord, come to page 24,
huh?
the notification, my lord.
Page 24. Yes.
24. Issued on, my lord, 1st of February 2019,
Hmm.
and serial number 6,
See,
my lord.
now kindly come to serial number 4,
4,
page 21.
rehabilitation of victim of human trafficking.
Huh?
Mean-
No. Kindly come to page 21, serial number 4. The victim or his dependent satisfying the following criteria shall be eligible for grant of compensation. Loss or injury sustained by the victim or his dependent should be caused substantial loss to the income of the family, making it difficult to meet their both ends without the financial aid or have spent beyond his means on medical treatment. That is 1.
Yeah.
Number 2 is the victim dependents report the crime in the officer in charge or so and so, provided that the legal source is satisfied for the reasons to be recorded in writing may condone the delay. The victim so and so cooperates with the police and prosecution during the investigation and trial. Where the perpetrators of heinous crime is not traceable or goes unpunished at trial, but victim is identifiable and the victim has to be rehabilitated physically and mentally, such victim may also apply for grant of compensation under so and so. So meaning thereby it cannot be a 5 lakh business. It has to be on the basis of perspective. Now, if it is a death and there is nothing out there, then you are entitled to it, taking into account the Apu's case.
Yes, my lord.
Hmm.
It is also death, my lord.
So, no, here let us see in exercise of the powers of page 24.
Page 24, my lord.
So and so of the Siman in exercise of the governor is pleased to amend. Description: victim of accident, victim of lynching, rape victim, death, 5 lakhs.
In this regard, my lord, the judgment of the Supreme Court, my lord, Quresh and another. And our High Court, my lord, Apu Datta case. Apu Datta case, my lord.
Yes, that is what I have seen.
Apu Datta.
That in Apurva's judgment, Apu Datta or something, na?
Yes, my lord. This is Suresh, my lord. And all the judgment are referred in the case of Apu Datta, my lord.
Now that I have seen it. Now there,
Yes.
if you look into it, section 357,
Yes.
it is the
357.
bounden duty of the magistrate to pass an order
Yes.
or at the time that for granting of compensation. If it is not done,
Yes.
then a scheme may be done under 357A.
Yes.
That's what the scheme is. Now, earlier, the amount which was given was 2 lakhs. Now it has been increased to 5 lakhs, taking into account the judgment in Suresh,
Correct.
isn't it?
Yeah.
That I know. So therefore, the question is, wouldn't that be if a person has been already convicted, the question will be for rehabilitation.
My lord, accused is convicted, yes.
Understood? If a person has been convicted,
Yes.
it is a question of rehabilitation.
My lord, regarding 357 has come. When the fine imposed under section 357 is not adequate, my lord, then 357 has come. 57A has come, my lord. My lord, I am reading the 357A. My lord. My lord, 357A. Every state government is in coordination with the central government shall prepare a scheme for providing funds for the purpose of compensation to the victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. Whenever a recommendation is made by the court for compensation, the district legal service authority or state legal service authority, as the case may be, shall decide the quantum of compensation.
See now,
Yes,
you see, if you read 357 and 357A,
yes,
a conjoined reading will show that an amount, a fine is to be paid
By
if
the-
there is any crime being committed.
yes.
Now, you see, in a case where there is no conviction, the question of fine does not arise.
Then 357.
Listen, Mr. Hussain,
Yeah.
if there is no conviction, the question of fine does not arise. So automatically 357A steps in.
Yes,
Now, if there is a conviction and a fine is there, but the fine does not commensurate with the loss suffered,
yes,
then a direction is to be given for the purpose of rehabilitation.
yes,
That is the scheme, what I could understand.
Yeah.
Now, in pursuance to 357A, the Assam Victims Compensation has been made. The total amount to be paid is 5 lakhs for debt maximum. You can't go beyond that.
yeah, yeah.
But how much otherwise is to be paid would only depend upon the question of rehabilitation. It is only a case of rehabilitation or being not able to sustain upon the death of that particular person. It is not automatic that a person dies, you get 5 lakhs. No. It has to be taken into account on the ground of rehabilitation. If there is no, if a person has been convicted and the fine does not commensurate with this, but the upper limit is fixed, 5 lakhs. It can't go beyond 5 lakhs. So the order which I propose therefore to pass, that yes, but the fact these aspects of the matter shall be taken into account by the DLSA and pass appropriate orders within 2 months.
Yes. My lord, there is another notification of the central, my lord, Nalsa, my lord. My lord, come to page 26, my lord.
What is it?
This is the notification regarding compensation scheme for women victims, survivors of sexual assault, other crimes, 2018. And it was, my lord, framed under the direction of the.
You are a woman?
Yes, my lord, woman. Victim is the woman, my lord. Daughter of the petitioner, my lord.
No. This is death.
Death, yes.
So,
here also, death also, my lord.
no, compensation for woman victims who is surviving.
My lord, come to page 38, the schedule.
Yes.
Serial number 1, my lord, loss of life. Loss of life, minimum 5 lakhs and maximum 10 lakhs. Loss also there, my lord. Loss of life. Here also death.
Now tell me whether the NALSA can override the government notification.
My lord.
Whether the NALSA can override the government notification.
Is
The government's victim compensation, can it be overridden by this?
well, my lord, this aspect we have to gone through, my lord, because I have not gone through.
Because that can't be done by the day or whatever may be. So your entitlement would be, your minimum will be 5 lakhs for this.
Yes.
Now, can you say that this will override? Show me that. Limitations under the
But
scheme, no claim so and so
Here
and so
also,
and so.
my lord, the procedure is to, my lord, paid by the DLS, my lord,
Hmm.
It's 30.
Just one end, the committee has revealed the so and so submission. Honorable Supreme Court further observed that while nothing to be taken away from the scheme, but it should not preclude the state government for eating the scheme. So this is done under what? Has been it been approved somewhere?
Yes, my lord, this is done, my lord, in pursuance of the judgment of the Supreme Court, my lord, page 27, my lord,
Page
page 27. Honorable Supreme Court in WC number so and so, Nipul Saxena versus Union of India. My lord, page 27.
will be appropriate if NALSA sets up a committee of 4 or 5 persons who can prepare model rules for victims for sexual demand. Whereas so has offered to assist the committee as when required. The chairman is in view of the set up by the committee members. Chapter containing the chapter shall be the Imam so. Team commissions have been made before the honorable bench was filed before the honorable Court of Iman. They say the Indian Central Bank has kept this scheme in line to provide the chairman of the state in their respective states. Where is this order?
Then my lord, come to
No,
page
Mr. Hussain, kindly come to page 29.
29, yes, my lord, come, last paragraph, my lord.
Last but one paragraph.
Honorable Supreme Court of.
No, last but one paragraph. Submissions were made before the honorable bench and other stakeholders were also heard on 10/5/2018. Additional suggestions received during the hearing were also incorporated in the final scheme was filed before the honorable Supreme Court on 11/5/2018. On this day, after hearing NALSA and the learned amicus, honorable bench was pleased to accept this scheme and directed so and so to implement the same in their respective state duties. So if there is a direction of the Supreme Court for this, then obviously this has
My
to be
lord,
taken
next
into.
paragraph, my lord.
Huh?
Next paragraph, my lord. the
Honorable
Honorable
Supreme
Supreme
further
Court of
observed
India-
that while noting should be taken away from nothing from this scheme, but it may appear to give more. No, giving more is okay, but this is for victims' compensation.
Yes, my lord. And the scheme is started from page 30.
But in the other 4 cases, there's no woman.
Moment. This
So
is the-
there other aspect will apply, but here
Yes.
is will be different.
Yes, my lord, here is different.
We do one thing, we keep this matter pending. You just find out this order of 10/5 or 11/5 of the Supreme Court
11/5.
in WPC number 565/2012. Huh?
Yes, my lord.
You just find it out, we'll take it up. Then we can pass appropriate directions in terms with the Supreme Court for the purpose of the state government enforcing, because that Supreme Court has already directed. Then it will be more better.
My lord, in last paragraph, said my lord, the Honorable Supreme Court
Mr.
of-
Counsel,
Yes,
who has written this? Who has written this? Tell me.
my lord, page 29, my lord.
Understood? Who has written it down below? Whose
Ma-
name is it? Director Nalsa.
Yes, my lord.
That's not what the Supreme Court has done.
Yes,
So
ma'am.
let's bring the Supreme Court's order and do it. What do you say?
Yes, my lord, I will collect this.
Directing the state government to formulate.
Yes, then you see whatever amount, this will be in addition to the other victims thing. So this is to be followed for women victims as well as the dependents of the women victims.
Yes, my lord.
I think that will be better. Huh? You'll be more famous then.
Sorry, my lord.
Okay. Taking into account the scheme. Taking into account the compensation scheme for women victims / survivors of sexual assault / other crimes, that's 2018, issued by the National Legal Authority, Services Authority. Let this matter, this court deems it proper that the matter deems it proper to observe that the matter would require a further examination as to what order have been passed by the Supreme Court in WPC number 565/2012. The Registrar General or what? Registrar Judicial. The Registrar Judicial of this court is directed to submit a report as to what steps have been taken pursuant to the orders passed by the Supreme Court in WPC number 565/2012, as well as the scheme above mentioned. List the matter again on 31st of August. Yes, Mr. Kamar. You see, something very important has arisen out here. Here is a case that the person concerned was died. It is the allegation of Mr. Khan's client that, look here, that person, there was nothing other, there was something wrong. There were a lot of other persons out there. That nothing has happened to them. And as such, it is a case of murder. What did an FIR was filed at Pallasbury? It was registered. Now, what has happened, interestingly, the judicial magistrate of Amingaon transfers that case to Nongpu.
Of a different state.
Can he do so?
For that, if your lordship will kindly look into section 177 of the CRPC matter. Actually, in a criminal case, ordinarily, it should happen where the place of occurrence has taken place. So,
No, I'm not on that. I'm saying, can the judicial magistrate
is that
transfer our investigation from one court which is within its jurisdiction, or from one police station which is within its jurisdiction to a police station which is outside the state where even this court does not exercise jurisdiction? 177 is okay. Every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it has been committed. There's no on that. But here we are concerned with, this is as regards the criminal courts, we are concerned with the investigation. Now, can the judicial magistrate transfer the police investigation? So it has a lot of implications out there.
in future,
Because that day, as I was telling him, can even this High Court transfer this investigation from here to Nongpu?
doubtful.
That is doubtful. It can be done by the Supreme Court. There is no quarrel because it exercises. Because if you take the same principles as regards, what do you call it? Section 24 of the CPC, or even the provisions of the criminal proceedings also, can this court transfer in exercise of the criminal procedure court, transfer a proceedings from here to Jharkhand? No, even the criminal proceedings, we can't do it.
Only zero FIR cases can be done.
That's a different thing, but these proceedings can't be done by this court. It has to be by the Supreme Court only.
And here in this case, as I see, my investigation is already commenced, matter.
That is what.
Court has-
How can the magistrate transfer it? We'll hear you on this. When?
After few days, matter, so that I can go to.
Yes, yes. And in the meantime, you produce that. The superintendent, how that order says that there is some order of the judicial magistrate. Yes, yes. Mr. Mohanto, you being the counsel for the Guwahati High Court, you see what has happened in this case, although we don't have that order, but it is reflected from an communication by the superintendent of police that the judicial magistrate, first class Kamrup Amingaon, transferred Polasbury PS case number 183/2014 to Nongpu police station.
Without jurisdiction to appeal.
That is what.
Without
Prima
jurisdiction.
facie to it
Prima
looks like.
facie, my lord.
Cannot do it, my lord.
Cannot do.
Understood. Now,
Lordship
what
is
has happened?
suggesting
In the
from-
meantime, the investigation has gone out there. There's a serious allegations being made by there is a, but the fact that it has gone out there has to be brought in. So we have to restore the Polasbury police station case. Now, how do you restore the Polasbury police station case out
Again,
here
it
if
will
the
be-
records are no longer available?
Again, it will be like a double jeopardy.
Yes.
Regarding the
But
same.
records are not available. Already charge sheet has been given there.
In
It's a murder case. Charge sheet has been given as an accident.
The worst part is that, my lord, in that said charge sheet, my lord, they appeared, pleaded guilty, paid fine, go out in a murder case.
304.
This is how it has happened.
No, 304A.
No, first of all, my lord, he is absolutely, he is without, how he can send it to.
That's the issue.
Now the file has been transferred by the superintendent of police, Kamrup, on the basis of that order to the Nongpu. And Nongpu police have made it a case of not a murder, it's a 304A accident. So what to be done? We'll hear this matter on when? 29th August?
No, may I wait one thing, my lord? Whether this Mestri is a party or
No,
not.
we don't know. Magistrate doesn't know.
Magistrate is not a party, but can this be done? You being the High Court counsel, you have to defend somebody.
No, if it is, yes, definitely, if there is a, surely if he is a party, then.
No, he can't be made a party.
Yes.
How can you make by person you can't make him a party? He has to be done either in the office.
Correct.
Now the office is at the office which has happened, I don't think what he has done. What he has done, he has made the state of Assam, state of Meghalaya, Director General of Police, Director of General of Police, all these people are out there. Lot of people have been made parties. But there he has investigating officer, Jagat Sutia. He's investigating also. Who is appearing for these private respondents? Notice?
They appeared also, my lord. Earlier order, they also filed affidavit.
Oh, they have filed?
Yes. 5 to 13, my lord. Affidavit.
None appeared. None has appeared for respondent, though the names of the councils are reflected. Okay.
Later on, they appeared, my lord. And they filed affidavit also.
Mr. Borpujari, you are appearing for the state of Meghalaya
Yes.
as well as for whom?
Also, I'm appearing for only for respondent 2 and 4. I have filed Vakalat on behalf of them.
But
Rest
why
are-
is it recorded in an order that you are appearing for the private respondents also?
They are private respondents, so I'm not for.
But it has been recorded out here that A. Borpujari appears for respondent number 2, 4, 16, 17, 18. This officer in charge, investigating officer, are you appearing?
No, your lordship. 16, 17, 18 are private respondents.
Hmm.
They'll have to get their own counsel. I'm for respondent 2 and 4.
Okay. So that this matter will listed again on
26, my lord.
no, put so. An issue has arisen in the instant proceedings as to whether the judicial magistrate first class Kamrup, Amingaon would have transferred the Polasbury PS case number 183/14 to Nongpu police station in the district of Ribhoi, Meghalaya. Mr. T.J. Mohan, taking into account that the said order has been passed by judicial magistrate, this court requests Mr. T.J. Mohanta, the learned Senior Counsel representing the Guwahati High Court to assist the court in the matter. The registry shall show the name of Mr. T.J. Mohanto, SC/GHC, in the cause list. The petitioner shall serve an extra copy of the writ petition upon Mr. T.J. Mohanto.
Already served. Already served. I had 2 extra copy. I have taken.
That's okay. Let me pass the order, then we pass. Copy of the writ petition upon Mr. T.J. Mohanto, the learned, so that he can assist this court. The learned senior counsel, so that he can assist this. This court also finds it relevant that taking into account a very important question of law arises. More particularly, in view of the submission of the charge sheet by the Nongpu police station, in respect to the transferred Polasbury PS case number 183/2014. As to what can be done by this court. Now, this court therefore requested Mr. J. Kamar, the learned senior counsel, to assist this court and assist this court. Therefore, Mr. J. Kamar, the learned senior counsel, duly agreed to assist this court, and he is hereby appointed as the amicus curiae. The learned, the registry shall show the name of Mr. J. Kamar in the cause list as an amicus curiae. Mr. F. Khan, the learned counsel appearing on behalf of the petitioner shall serve an extra copy of the writ petition upon Mr. J. Kamar, the learned senior counsel. It further appears from the communication dated 29/3/19 issued by the Superintendent of Police Kamrup Aminga, whereby the petitioner was duly informed that on the basis of the judicial magistrate, on the basis of an order passed by the judicial magistrate first class Kamrup Aminga, the case diary and other connected papers were handed over to the OC Nongpu station, police station, on 25/11/2014. Mr. B.J. Taluk, the learned counsel, appearing on behalf of the respondent number 3, 1 and 3, is directed to produce the records maintained in the office of the Superintendent of Police Kamrup Aminga in respect to the Polasbury PS case number 183/2014, as well as also the order of the Judicial Magistrate First Class Kamrup Aminga, on the basis of which it was mentioned in the communication dated 29/3/2019 that the case records of case diary of Polasbury PS case number 183/2014 was handed over to the OC Nongpu police station on 24/11/2014. Mr. So-and-so A. Barbuzari appears on behalf of the respondent number 2 and 4. and submits that he would like to file affidavit. As the Mr. A. Pujari is further directed. No. This court directs the respondent number 2 and 4 to produce the case records You know the Nongpu police station case?
Yes,
What is the number?
pilot page
Number for number.
91.
You don't know the number, or should we put 91?
Nompo PS case number 187 within bracket Roman 2 14 under section 302 IP. Case 91. In the order sheet it is reflected, my lord.
So it is now lying in the court.
Already, my lord, it has been disposed of, my lord, and it was GR case number 3.
So how can he produce it? He can't produce it.
My lord, it will be, my lord, GR case number 342 of 2014.
Now, how can he produce it? He can't. We have to call for the records of this.
Yes.
There's no other way.
Meghalaya Council can probably bring it.
Yes, Meghalaya.
Huh?
Meghalaya Council can probably bring it, madam.
How-
Instruction.
You can get it.
Sir,
Get the scan copy. Mr. A. Pujari, the learned counsel appearing on behalf of the respondent number 2 and 4, is directed to obtain scan copies of GR case number 342/2014. But can you get it?
I'll have to obtain instruction first.
No, you can't. Can you get it? He can't.
He's repairing the statement.
But he's paying only for the, but this is pending in the court. But can he get it?
Home department.
Because normally when we call for the case records of a court, we call the from the court.
Registry can take up call.
Now he's directed to produce Mr. A. Pujari, the learned counsel appearing on behalf of the respondent number 2 and 4, is directed to produce the scan copy of the case diary in respect of Nongpu PS case number 187 Roman 2 14 public 14 registered under section 302 of the Indian Penal Code. Pusto. Mr. Mondo, can this court direct the for the scan copies of these from these Nongpu courts?
Why not? It is now Meghalaya High Court is separate. So our is the.
But if this court is exercising jurisdiction under 226, can't they do it?
I think your lordship can-
I'm only asking for
Yes,
scan
yes.
copy.
226 can.
But this court is exercising 226.
226, yes. Or otherwise, government can throw registry of the Meghalaya government, my lord, they can do it, my lord.
How can he get the records of a charge sheeted case which has been filed already?
File disposed of.
A scan copy of the year along with the copy of a charge sheet. There's a charge sheet, na?
Yes,
Charge sheet dated?
Charge sheet.
My lord, my lord, page number
Charge sheet
71.
number 45, madam, I think.
Yes.
Charge sheet number
45 of 2014.
Page 71.
Dated 6/4/2015.
Oh,
madam.
thank you. Along with the copy of the charge sheet dated so and so.
6/4/2015, and the charge sheet number is 45 of 2015. Under section 279, 304A, 427.
This court further directs the registry of this court to obtain the case records pertaining to GR case number 342/2014 pending before the court of. What court is this?
Just dispose of.
District? Huh? What is
The
it?
case has been
DNJ?
disposed of, my lord.
Huh?
The case has been said to be disposed of, my lord.
Is no longer there.
No, it's already paid fines, pleaded guilty, paid fine and disposed of. 302 case become 304 case. Your lordship will get it pays 106.
No, what is the, which court is this? From the court of D,
That will be magistratal court, my lord, if it is an accidental case. The order is on
directed to
pays
procure the,
105.
to
105.
requisition the scan copy of GR case number 342/2014 from the court of DSJ. Huh? No, DSJ is what?
Which one, my lord?
Srimati MB Chalam DSNJ Nongpu Court.
Yes, my lord.
District Nongpur.
Nongpu Court.
Srimati MB Salan, DSJ Nongpukot. Nongpukot what?
Huh?
District and session judge Nongpu.
Isn't it?
Yes. Page, my lord, 91.
District and session judge Riboy, Nongpu.
But the sections of magistrate tribal.
Huh?
Magistrate tribal, my lord.
Ah, this
It's a
is,
type code, yes.
no, this is not district and session
Yes,
judge.
but this DNJ. District and session, page 92, there's a original. Your lordship kindly see page 92.
DNJ.
DNJ, Nongpu Court,
DNJ is what?
district and session, I think. DNS, my lord. DNS.
Yeah. Very relevant. You see, page 92, you see. Also seen the case record transferred from the Honorable Court of the CJM Kamrup Amingaon to this court. You see this? Page 92, the last line.
Yes, also seen the record transferred from the Honorable Court of CJM Kamrup, Amingaon to
So
this
this
court.
record is there.
Yes.
Ah,
My lord, 94, if your lordship will turn it, you will see the name of the magistrate, my lord. This is, and was the case to my
okay.
file.
From the
Srimati
court of the
M.
Chief Judicial Magistrate,
Magistrate.
Nongpu.
94.
Yes.
M. K. Lingu.
Certified copies were obtained from there only.
We have got it from there.
Page 63, my lord, the form,
Page
63. The certified copies were given to us from the here.
Chief Judicial Magistrate.
ठीक है. From the court of the Chief Judicial Magistrate Nongpu, GR case number 342.
Yes, my
Just
lord.
list the matter again on. We'll have it, not otherwise. We'll have it on. Some more time is required. 12th of September.
Let the records come then. In the meantime, we will go by preparation.
12th of September.
Much of that.
Yes.
May it please your lordship, my lord. My lord, this case is filed seeking compensation for handcuffing the petitioner who happens to be an advocate.
So advocate can be handcuffed.
No, my lord, according to the police manual, Assam police manual, advocate, jurist, and then there are certain professionals, my lord, who should normally not be handcuffed.
What is this normally business?
My lord, because say, except if they try to abscond the jurisdiction, if any attempt is made, my lord, then only they can be handcuffed. Otherwise, they cannot be handcuffed. So, my lord, here.
So what are you asking for here? For
My lord,
compensation?
Compensation. My lord.
So how does this court assert in that?
My lord.
1 rupee?
Yes. 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 Lordship. Yes, absolutely.
Show me, it cannot be done.
My lord, this is. I'll initially show, my lord, that it was done, and then I'll show that it cannot be done, my lord. My lord, may kindly, this is a small compilations, my lord, of the relevant laws, my lord, of handcuffing, my lord. This is the first page is the list of date, my lord, how they have done the investigation, because it was a quarrel between a police and a advocate. The informant happens to be a police, and there was a counter FIR also. The counter FIR culminated into a final report under 173. And interestingly, this boy was charge sheeted. However, he was exonerated by the court below because of deficiency in the evidence. However, my lord, during cross-examination of the police personnel, the police personnel have clearly admitted in the trial that yes, I have handcuffed him. And there is also, it has come on record, my lord, that the accused have himself, the petitioner in the case, my lord, has surrendered before the police, my lord. So, my lord, at no point of time there was any occasion to even remotely infer that he was trying to abscond or anything, my lord. Notwithstanding that, my lord, he was handcuffed, my lord. Now, my lord.
What are these offenses under which? What is 294?
294 is obscene words, then 325 is hard, and the other is obstructing a public servant from discharging public duty, probably 353. These are the three sections.
341?
341 is wrongful confinement, probably. Yes, my lord, 341 would be wrongful confinement. Wrongful restraining any person. And I have been exonerated of all this stuff.
That's okay. But now tell me, it cannot be done.
Now, my lord will kindly come to this compilation, little compilation which I have made, my lord, at page number 1 of my compilation, my lord, which is Rule 214 of Assam Police Manual, my lord. My lord will kindly see sub-rule B. The principle as regard the use of handcuffs is the same in all cases, whether bailable or non-bailable. Namely, they should be used when a prisoner cannot be secured without them. In practice, the following instructions should be observed in case of handcuffing in a bailable and non-bailable cases respectively. These are, so my lord, they should be used when a prisoner cannot be secured without them. This is one. Then I'm relying that if your lordship.
Handcuff will generally be employed in non-bailable cases unless the prisoner owing to age, sex, infirmity can be easily and securely kept in custody without handcuff. You don't come within that.
No.
The amount necessary is, however, left to the discretion of the officer.
My lord.
In bailable cases, should not be handcuffed unless violent.
My lord.
Are all these offences bailable?
353 is non-bailable.
So then the B does not apply.
My lord.
Number 2. Now, which one? Where is it the advocate cannot be done?
Yes, my lord. My lord will kindly turn to page number 2 of this compilation. The notes attached to that, my lord.
Note?
Notes of the Assam Police Manual, my lord. My lord will kindly see, I'm reading 1, 2, 3, 4, 5, 6, 7, 8. The 8th line of the notes, which starts from the word, the indiscriminate resort to handcuffs. My lord is there, my lord. The indiscriminate resort to handcuff when accused person are taken to and from the court, and the expedient of forcing irons on prisons inmate are illegal and shall be stopped forthwith, save in small category of cases. Reckless handcuffing and chaining in public degrades, puts to shame finer sensibilities, and is a slur on our culture. Then Justice Krishna has that observation. I'll come to that. Now, my lord, may come point number 5, bottom, my lord. Handcuffs should not be used in routine. They are to be used only where the person is desperate, rowdy, or is involved in non-bailable offense. There should ordinarily be no occasion to handcuff person occupying a good social position in public life, or professionals like jurists, advocates, doctors, writers, educationists, and well-known journalists. This is at best an illustrative list. Obviously, it cannot be exhaustive. My lord. So, my lord, here is a case, my lord, where this man, my lord, even presuming whatever the police have narrated to be true, Here is a man who has voluntarily gone, who has surrendered before the police, my lord. Notwithstanding that, my lord, he was handcuffed while he was produced before the chief judicial magistrate.
No. How did you surrender? You were the allegation. When were you arrested?
Absolutely, my lord. My lord, the FIR, I was arrested.
When did the incident happen?
My lord, the FIR incident happened on 5/10/2016. On that very day, my lord. My lord, if I may take your lordship to one particular page of the petition, my lord.
No, okay, but tell me, on the day you have been alleged on various offenses. One is a case of obscene words.
My lord.
These are allegations.
My lord.
One is a case of
Wrongful
confinement.
My lord.
One is a case of 353
Yes, restraining a public servant from performing.
and 341.
341.
And another one, no, whatever may be. When did this offense, as per them, was committed?
On 5th, my lord, on 5th of October 2016.
Okay,
On
when
that-
were you arrested?
My lord, I was arrested on that very day in the evening, my lord, though I was produced on 6th, the next day.
No, I'm not concerned. You were arrested when?
Now, my lord, I was arrested on 5th,
Immediately.
that day evening, my lord. But however, my lord, the date of arrest will be counted from the date when he was produced before the.
I'm not on that. You see, you have been handcuffed where? When were you handcuffed?
I was handcuffed on 6th.
Not on 5th.
On 5th, I went to the police station. I was not handcuffed because I was inside the police station. On 6th, when they produced me before the learned court below, in terms of within 24 hours, I was handcuffed. While I was brought to the court, and then from the court, when I was taken to the judicial custody, during that transit period, my lord, I was handcuffed, my lord. There are, my lord, if your lordship permits, my lord, there are judgments of the Supreme Court, 3-judge bench judgment, my lord, through Justice Krishna Iyer. There is one judgment where this practice has been absolutely depreciated, my lord, which is followed by one judgment of our High Court also, my lord, where one judgment of our High Court where the compensation of 10,000 was given for the state exchequer. That also I have ensured that whether for an act of a police officer, whether the state will be liable, that law is also settled, my lord. Even in the Bombay High Court, as well as our High Court has given compensation is to be awarded from the state exchequer. Because they are, the police personnel are working at the behest of the state, my lord. So it is a state action because of which a person's fundamental right or dignity was being, his dignity was affected.
But whether the fact it is admitted that you were arrested handcuffed?
Yes.
On 6th?
It's 6th, my lord. I was.
No, you were handcuffed on 6th.
Yes.
That is admitted.
Admitted. 6th, the date precisely is not there, but I was handcuffed, it is admitted.
When that is the, on one hand, you are saying here the Supreme Court, Krishna Iyer says that rowdy, a person whose allegation is that you have been using obscene words, is the allegation against you?
My lord.
If that be so, how can you say that it is not, it may be a case of rowdy?
My lord.
You may have to be restrained. That is why I asked you, when were you?
16th. 16th is that. 16th.
6th.
6th. Yes.
Now, if it is on 6th, have anybody admitted that you were handcuffed on 6th?
Yes.
And not 5th?
That is precisely I was trying to indicate that page. I was handcuffed is being admitted by the man who was handcuffed.
And on 5th or 6th?
On 6th, my lord.
No, has he admitted on 6th? I'm saying that. There's a difference, no? If it was done on 5th, it is a different aspect. You see the allegation.
Yes, my lord. But
an allegation, whether it is proved or not, that's a different thing. But the allegation is you have tried to wrongly restrain, which means the element of rowdiness is there. Obscene words are used. So on that date, if it was you were handcuffed, it is a different aspect. But whether you were handcuffed on 6th is the question out there.
My lord, my respectful submission would be that, my lord, if your lordship just, my lord, I was just trying to indicate, my lord, may kindly come to page 42, my lord.
For what?
Page 42 to page 42 of my petition, my lord.
Yes.
My lord is there at page 42. I'm a penultimate paragraph. The accused had surrendered at the PS and the offences against him being non-bailable had forwarded him before the learned court. Now, my lord, will see the next page, my lord, at page 44.
44.
The last line.
Yes.
I had handcuffed the accused.
When?
Now, my lord, this has been done on 6th because, my lord, he was produced before the judicial magistrate on 6th because the
Where, how it is an admitted fact that it was done on 5th or 6th?
my lord, be that as it, my lord, whether it is on 5th or it is on 6th.
No, 5th, there is a difference.
No, my lord, I'm just assuming that
Offense is bailable, non-bailable. As per them, the offense is you are accused of rowdiness. So Justice Krishna's judgment doesn't, right? And that is also not stated out there here in the police manual. It is stated only non-bailable offense. There are aspects, but if it's a non-bailable offense, obviously.
my lord, the word rowdiness is not used in Krishna Iyer's judgment, my lord, because the word rowdiness is there in the Assam Police Manual. However, my lord, that note of the Assam Police Manual, in my respectful submission, has to be read along with the 214, which says that
Are
only.
you saying that note is a part of the Assam Police Manual?
My lord, that is.
Or is it this policeman, these note is a part of a compilation of a book?
Now, my lord, the notes, because since it has been incorporated in the Assam Police Manual that
No. Is it in the compilation of a book published by a publisher?
Published by publisher that.
Or is it a part of the Assam Police Manual as it is?
The notes.
So if it is published by a publisher, it shall not be a part of the Assam Police Manual.
Absolutely. So, my lord, the Assam Police Manual, Rule 214, Sub-Rule B, clearly says they should be used when a prisoner cannot be secured without them. That is the mandate of the police manual. Now, my lord, this has to be read with the judgment of the Honorable Supreme Court and our High Court. Assam Police Manual at page number 1 of my compilation, Rule 214, Sub-Rule B.
What do you say about Sub-Rule B1? Handcuffs will generally be employed in non-bailable cases unless the prisoners owing to age, sex or infirmity can be easily secured. And you are a person who would not come within the exceptions. So it is a non-bailable offense, so you can be put. Why not?
Because, my lord will kindly come to compilation page number.
Mr. Viswas,
Yes,
you
ma'am.
do one thing.
Yes,
You go through it. We'll take it up on 17th and dispose it of
absolutely.
at 2 o'clock.
17th. 17th is yes. 17th. Well, can it be on 16th?
16 not possible.
17th.
All other council may, because I will dispose it of in your presence. 17th,
17th.
2 o'clock.
So,
It's the matter again on 17th at 2 o'clock for further hearing.
it's not the quantum of compensation is immaterial here because, my lord, this man has he has taken this to the other side, my lord. I'm deeply obliged.
You get the judgments, not
Yes.
these notes.
The judgment-
How it is to be done.
Absolutely, my lord. The compilation is there. I've given it.
Because you can't say that normally an advocate can't be, or a jurist cannot be handcuffed. No. It has to be gone as per the police manual. Now, if the police manual says to the effect, because here the allegations which are being made against you has the tendency of a rowdiness. I'm saying whether it has happened or not, this needs to be looked. Yes, next.
I'm deeply.
28. Yes, madam. Why no order has been passed? On 28/5/2021, this court passes an order to dispose of their representation. Have you done that?
No instruction, Your Lordship.
Madam, what is wrong with this GST department? We call the commission of GMC to the court. I think that is a better option. No instruction in all the matters, 3 matters, it has happened, no instructions. And you have, in spite of our direction passed by this court, you have not complied with.
Lordship, maybe taken up day after tomorrow, Your Lordship. I think.
List the matter again on 14th will be closed. On 16th of August 2023, on which date the learned counsel appearing on behalf of the petitioner shall obtain instructions as to whether the representations submitted by the petitioner dated 2/2/2021 had been disposed of by the Commissioner Central Goods and Service Tax Guwahati. It is made clear that if such instructions are not produced, obtained, the Commissioner Central Goods Tax Guwahati shall be personally present in the court. 29.
Lordship, I have one more prayer for item number 20. Lordship, that has been fixed on 30th. Lordship, 30th is Rakhi. Any
Which
other?
one?
Item number 20.
20 it is done. I can't help you.
Okay, that
Come
is-
after Rakhi. Yes, next. 29. Yes,
The VAT, my lord, that is excise.
madam, you are not serious in the matter.
Lordship,
You are not serious with the matter.
I
Why
am.
haven't you filed an affidavit? Is the huge stakes
No,
involved?
Lordship, we have received the instructions. We'll file
Then-
an affidavit.
This order was passed how of when? With the state? 5/3/5/2021. On one hand,
No,
this is a
Lordship, there
huge
were
amount of money.
some
You don't
discrep-
require.
Some discrepancies were
You take
found.
that money and give it to some charitable institutions if you have so much of money. Then when you are filing,
I would pray for 3 weeks time, Your Lordship.
6 weeks,
3 weeks.
when? Give me a date.
Eleven.
30th of August, Your Lordship. 30th of August.
Your name?
M. Kalita, Your Lordship.
Ms. M. Kalita, the learned counsel appearing on behalf of the excise department submits that the affidavit would be filed on behalf of the respondent excise department by 30th of August 2023 without fail. So taking into account the above, list the matter again on 13th of September, 13th, 1/3,
Other two matters are fixed on 11th, my.
on 11th of September. 11th, why?
No, there
Your
is
lordship has fixed the other, there were, previously there were two matters.
On 11th of September 2023. Good stuff. In the meantime, the petitioner shall also be at liberty to file their affidavit in reply by 8th of September.
I'll utilize, Your Lordship.
30. Interim order passed earlier shall continue till then. Yes.
May it please, your lordship.
Mm.
My lord, the petitioner before your lordship is a commission vendor, my lord, before, in the Guwahati railway station. There is an agreement, my lord. And pursuant to
Yes, tell me.
the agreement, my lord, I was carrying on my business. Finally, what happened, my lord, one termination letter was served to me that it is unsatisfactory. My business is,
Commission letter.
no, termination.
No, commission what? You were?
Commission vendor. It is commission vendor means, my lord, railway authorities supply me all the articles. I just sell it and I take the commission.
Then you were
thereafter-
terminated.
Yes, terminated notice was there. Finally, my lord, I have come to know from the affidavit that termination letter was withdrawn. My phase is from 2020 to 2025 for 5 years. My lord, that without that, that termination letter is now withdrawn. And subsequently, my lord, one NIT was flown. In the same premise, my lord, another third party is now put into it, and my lord, I am forced to vacate the place. That is the question, my lord. One and my lord,
Vacate the place means?
vacate the premise, my lord, that tenanted premise. That commission vendor, my lord, I was offered a place. where-
You vacated it.
Yes, forcefully vacated, my lord.
Then what happened? What
That-
remains?
My lord, here where one another angle is there, my lord. There, my lord, all throughout this matter has come up, and many times, my lord, at length it was heard, but cannot be disposed of, my lord. There was another angle that there is a clause of rotation rotation means, my lord, my shop can be rotated, my lord, what I understand, with another similar shop that I may be rotated in that manner. But in this case, my lord, my allocation was not informed to me. My lord, this comes from their own affidavit, my lord. It is only 24/3/2007, 24, that 2023 I have come to know, my lord. That is the, my lord, crux of the matter is this, my lord. And my lord, this shop was, my lord, originally run by my father, thereafter by my mother. Therefore, when my mother,
Shop or what?
it's a, my lord.
On one hand, you are
it's a
saying
unit.
it to be a commission agent.
Yes, it's a unit, my lord. But units, all these products are being supplied by the railway. South Indian snack bar. All items are given by them. We just sell it, my lord. And once we sell, we get a commission of it. And my lord, our business was running very
So
good.
you don't have a identity of yourself.
I'm a commission vendor, that much, my lord.
So you sell on their behalf.
On their behalf.
The
And
name is of the railways, South Indian Snack Bar.
snack bar, my lord. And
Is of the railways.
this is our name only, my lord, because my
Then
The owner and possessor, everything.
Ron,
yeah. And your case is of 2017.
no, that's not my
No,
lord.
no, it's little bit
It's-
different. Those
it's a
are
different-
licensed vendors.
Ah.
He is a commission vendor.
The commission vendor is what?
These are departmental stalls owned by the railway, my lord. Every expenses with regard to the stall is borne by the railway, my lord. The food items that are sold are provided by the railways. The electricity dues, water dues, everything borne by the railways. Even the crockeries, my lord. He just sells the goods on behalf of the railways and earns a commission, my lord. Now, if you can show from the agreement that he has been appointed as a commission vendor for that particular stall, my lord, I'll not argue my case. He's just a commission vendor, my lord.
My lord, it is,
No such thing as
that is too, my lord. Just, he is just.
Matter having been heard, let the matter be taken up tomorrow at 2 o'clock.
Yes.
Final judgment. Take it. I'll pass the order tomorrow.
My lord, here, I have to submit something, my lord.
What?
One aspect is left out. They said.
You submit 2 o'clock.
Yes.
I'll
Yes.
pass the order in your
Of
presence.
My lord, affidavits have been filed, that may be kindly be directed to be tagged together.
You show me a photocopy.
All right.
31. When?
Right, please.
Yes.
But the readings are complete, my lord. But however, I need certain instructions from my clients, my lord. Some time may be given to me, my lord.
What is this?
The
What
actual
are you
code.
challenging?
But I am specifically challenging an order which my lord will find at page number 45. Whereby I have been asked to demolish a particular structure, my lord. However, there is another order passed by this honorable court, which my lord will find at page number 40.
Oh, this is for vacating the land. Huh? This is something in terms with Rule 18.
NC Hills, Lordship. NC Hills.
Huh?
NC Hills, Lordship. What our affidavit states that he has enclosed the portion of the land. The portion which he has enclosed has to be vacated, Lordship. That is
what right do you have?
But I need certain instructions, my lord.
For what?
As to how the encroachment, is there any building or is there any, as they are alleging?
No.
Is there any-
Building house, you may have a 3-storied or a 6-storied or a hut. That is immaterial, but it is the land of the government. How do you remain there? Unless you show some justifiable reason.
My lord,
So justifiable reason. Yeah, look here, these people have allowed me to stay there.
Lord, I'll have to get certain instructions from my client, my lord. Yeah, otherwise, there's already an order passed by this honorable court, which. my
Or
lord
not
will
to
find it-
disturb you.
My lord.
Not to disturb you.
No, my lord, not to disturb me in respect of they have not issued any chokers notice to me. A proceeding has to be there. Thereafter, my
Till returnable date, the impugned notice dated so and so with regard to the petitioner hearing shall remain suspended. And the interim order has been extended. Let me fix it after you say that there is nothing important out there. Let me fix it after 10 days. And I say that there is no interim order. Let's see what the consequence is. What do you say?
my lord, my case entirely is based on that.
You have no right. Tell me.
If, yes, my lord, if at all, they would have been issued me with a notice,
You want a notice?
my lord, a notice to be issued by them. They have.
For what?
They have to process it, my lord. They have,
No, notice for what?
at least, my lord, an inquiry should be conducted in my presence. I'm entitled to at least that, my lord. That whether they have given some figures in the affidavit, which for the first time I have come to know before this honorable court. I've not come to know before that. At least some measurement is to be done in my presence, my lord. I do not know whether these
Let's
are.
see the affidavit, what is there?
Lordship,
What is the area has been given? Is holding a plot measuring 13 katha covered by patta number, Iman of Dag number. She has encroached 12 feet of PWD roadside land, which is a government land by constructing. The so and so is holding a plot of land measuring 6 katha by Iman in so and so. She has encroached 12 feet of PWD road. So you have encroached PWD
This is
road.
the only data that I have,
Then how do you encroach PWD road?
my lord.
For you, there are a lot of people are suffering.
My lord, my lord, if an.
Get your instructions. Get your instruction. We'll have it on 16th and matter is way over.
My lord, can it be on the next week, my lord?
That is what, 16th?
No, my lord, starting from 21st, my lord.
No.
I won't be
This is the
available,
matter
my lord.
again on
That is my problem.
16th, on which date the learned counsel for the petitioner,
My lord,
16th of August 2023, on
if I may
which date
pray,
the
my
learned-
lord, I
Yeah.
won't be available, my lord. I have to take my father to somewhere, my lord.
You have a VC,
My lord. I'll-
This- on which date an attempt shall, on which date the learned counsel appearing on behalf of the petitioner shall obtain the necessary instruction. Okay, we'll have it on 21st. Monday is a better day.
My lord. I'm deeply obliged.
32.
Wait,
Yes.
morning there was a prayer, my lord. Because of shifting of my chamber, the file was misplaced. My lord, so my lord, I have seen from the second copy, the impugn order is at page 18. I was allowed a contract, my lord, then thereafter, my lord, some extension of time was given, but I could not complete because of Corona and others. So my contract was terminated with some penalty clauses were there.
Bank guarantee also.
Bank guarantee, I think no, it's not there, my lord. Page 18 is the impugn order.
No, there is no order being passed out here in your favor
No, my
by
lord,
this court.
no, my lord.
Your termination has been done.
Uh,
No, there was an order. You said that you would have completed. There was a direction to look into it. Yes, Mr. Dhar, anything has happened?
We have already, my lord, filed affidavit, my lord. In this.
No, what is your stand?
Our stand is, my lord, that we gave him 6 month time. And thereafter he could not complete. We gave him 4 notices. Complete it. He could not do it. We terminated, my lord. We gave him- and my lord,
The
maybe
work? What has happened?
work, maybe, my lord, we have.
But
That is
till
something I
now,
don't have.
nobody has, nothing has been given, nobody has.
That
We
information I
gave an
don't have.
undertaking in an affidavit that we will complete by November. Still then there was an affidavit on my.
Ah, after termination only he has given that affidavit.
No,
my lord.
No, by, let's be more reasonable.
Well,
From 2021 till date, has there been any work?
No.
Has the work been completed?
that I will find out, my lord, because that is a
This is the matter again on 23rd of August 2023, on which date Mr. Ardhor, the learned counsel appearing on behalf of the petitioner, PWD, shall inquire, shall obtain instruction as regards the status of the work pursuant to the termination of the petitioner.
I will find out there was any new.
Oh,
And I
just
will-
find out.
and- my lord.
33. Yes, what in records do you have? Did you issue notice to him?
Lordship, as per telephonic clarification instruction that I received, there is no record of issuance of notice under section 37. 36 is there, Lordship. Thereafter, the order sheets are also there, where they were supposed to appear on a particular date to submit some more document, but they never appear.
Did they appear?
On the second, under notice under 36, they appeared, Lordship.
36 of the VAT, they
Yes,
appear.
Lordship. Yeah.
What is this 36? Let's see.
Lordship, section
That one
36 Lordship, section 36 relates to audit assessment, which says that before initiation of proceedings, section 36 notice has to be issued. But once an assessee fails to comply with section 36 notice, and if the assessing officer proceeds to assess him, in that he has to issue a compulsory notice under section 37, Lordship,
stating what he intends to do with the assessment and giving a reasonable opportunity of being heard. So
If
our case
you
is
are saying about for 37,
37, Lordship. It has not been
36
issued.
is what? Audit assessment.
Initiation, Lordship.
Audit assessment, when a registered dealer is selected for audit assessment by the prescribed authority on the basis of any criteria or random basis, the register is not satisfied with the correctness of funds or input tax credit and the mean external factor may have already been assessed under he must serve upon a year in the prescribed notice requiring him to pay. So they have gone for 36 and issued notice.
Lordship.
Then what happened?
Then subsequently, it is their case that I have not complied with the notice.
Uh,
So they have passed an order and as per section 37, Lordship, they ought to have issued another notice.
The prescribed authority shall, after considering all the evidence produced in this demand, confirm the self-assessment under 35, set aside this demand and set aside, assess the amount of tax due to the dealer if no assessment has been made under demand. Provided if he proposes to rely on any evidence collected within it shall be. So you are saying about 37. So 36(5) says
Yes, Lordship.
that the prescribed authority shall also consider all evidence produced either confirm. So he has three options.
Yes, Lordship.
Either to confirm the assessment under 35,
Lordship.
set aside the self-assessment and made and assess the amount of tax due from the dealer.
Lordship.
Now, what is this assessment?
Lordship, it says after considering all the evidence produced in the course of the proceedings, but it is an admitted position that admitted I have failed to comply. When we talk about failure to comply, Lordship, it is 37C, 37(1)(c).
No, we'll go to 37. But what do you say about 36(5)(b)?
After considering all the evidence produced, no evidence has been produced before him.
Understood? No, you have given a notice.
Yes, Lordship.
As regards he is not satisfied with your return. That is 36.
Lordship.
And after that, you have been asked, whatever you have produced or not, what is the course of action which is to be done by the assessing authority? He'll do, if the prescribed authority will exercise the powers under 36(5). He has three options.
If I produce evidences.
You know, no, if you don't produce also.
No, Lordship, proviso covers it.
No, after considering all evidence produced, meaning thereby, if you don't produce, are you saying that he cannot set aside the assessment or cannot confirm it?
He can, but he has to issue a notice.
So
Again.
whether, you see, you will be given an opportunity to produce. Now, if you don't produce,
Yes, Lordship.
the authority will take it as if you have nothing to produce.
It is covered by the proviso, Lordship,
Yes.
36(5) proviso, which says if the prescribed authority proposes to rely on any evidence collected by him, the dealer shall be afforded a reasonable opportunity of being heard. When I fail to comply, Lordship, 37(1)(c) comes into play.
37 and 7. What do you say about 36(5)(b)?
I say that, Lordship, after considering all the evidence produced in the course of proceedings, when I have not produced any evidence, he relies on his own. When he relies on
Or
his own.
collected by him, You see, in course of the proceedings or collected by him,
Yes, Lordship.
either, why I'm not saying on the other aspect, I'm saying here, either confirm the self-assessment, so he can confirm your assessment. Set aside the self-assessment under section 35 and assess the amount of tax due from the dealer, meaning thereby he exercised the power under 36(5)(b).
Yes, Lordship.
And this 36(5)(b) has to be read with 37. That is his best judgment. That is what I am trying to say. So 36(5)(b) has to be taken with 37. Now, when he takes new evidence or anything collected by him, he has to give you an opportunity. And that opportunity has not been granted. Now, that is your point. Yes. Why you are not asking, allowing me to go beyond that? Yes, now you get that point. Now, at the time when you did the best assessment, did you take into account any other evidence collected by you? And if so, did you give him an option? There we come in.
Lordship, if Lordship goes by the assessment order, he has not collected any new evidence. It's only on the basis of the annual return that he has filed under section 35 self-assessment.
on that basis, since he has not produced as requested on a particular date to produce further documents, Lordship, on that basis.
So he
has made-
decided it
Yes,
without any taking anything, but on the
Yes.
basis of that.
yes,
So there is no question of any fresh evidence being taken.
yes, Lordship.
So under such circumstances, this is being done under 36(5)(b), read with 37. So
Yes.
for that, and a separate notice is not required because
Yes.
he has already been given that notice.
And in that section 36 notice, Lordship, at the bottom of the notice, it states that, Lordship, if please take notice that in the event of your failure with a sufficient cause to comply with this notice, you will render yourself liable to be assessed to the best of my judgment without further notice to you.
No, that is why it is given. So therefore, 36(5)(b) has to be read with 37.
Yes.
So that is being done. So he did not rely upon any new
Yes,
thing
as
except
far
on the
as-
annual return.
Yes, sir.
Now, the second is the point of limitation, which he has raised. What is it?
Lordship, section 39 says that of course, sections which forgoes the section 39, it can only be for 5 years from the end of the applicable year. In this case, Lordship, the financial year is 13-14. So when it is 13-14, 15-16, 17-18, 19, before 31-3-19, they ought to have completed the assessments. Now, Lordship will produce the demand notice which has been issued to me, which is at page 28. Lordship will see the issue 640-41, date of issue 17-19. Demand notice has been issued on 1 July after 31-3-19, but the date has been mentioned on the notice 27-12-18 below.
Okay.
Lordship will again peruse the assessment order at page 31. Before the table of the assessment order, top left, it says 21-12-17. What is this manner of passing orders, Lordship? They pass an order on 21-12-17. They issue a demand notice on 27-12-18 after 1 year, and they again issue it after 6 months by putting the issue number.
Is this the notice, or this is the notice of demand?
Yes, Lordship, as per the impugned assessment order.
So this is a notice of demand.
Lordship.
So you are
Which was
saying
served upon me.
the order was passed on 21-12-2017.
Lordship.
And the notice was issued on 2/7/2019. So what is wrong?
31-3-2019 is the last date on before which the assessment ought to have been completed, Lordship. What makes them keeping it pending for 1.5 years after issuance of assessment order?
But here, is it a case of initiation of an assessment proceedings? Or is it the case of a late demand being issued pursuant to an assessment order?
Lordship, they have to justify the delay. 1.5 years after copying of the assessment order.
Now, is it not permissible as per the Act to issue after the assessment order? Yes, they may not be entitled to the interest on that. That is a different thing. But the question is as to whether there is a bar on the part that once you issue the assessment order within 3 months or 6 months, you have to issue the demand notice, or within 1 month thereafter. If you don't do it, it is ghost.
That aspect I will have to look into.
Chalo, we'll have it on because the matter has been done. List the matter again on 17th of August 2023 for final listing.
Your Lordship, there are 2 similar matters where the similar petitioner, if it can be taken up together for
Let
disposal.
your faith as of now is not so good. So why you spoil the other 2 matters? Let us see
The
first.
fate will have to be same, Lordship. The fate will have to be same.
Okay, we'll list it along with.
Along with the Lordship, WPC number 5219 and 5299
of
2021, Lordship.
Lordship, I have received the instruction. In the meantime, I will find.
You do whatever you want, because you see that you have you can produce the records.
Yes,
If you have
I will get it.
Because then this is, you see, the first point is this.
Yes.
You have not taken into account. So if you can produce the records, we can take it out. And the second is, as regards if there is a delay in issuance of the notice of demand, would it be next? 34.
Lordship, 34 may be taken up 22nd of August. Your Lordship.
22nd. List the matter on 22nd of August 2023 along with a Arveta matter.
WPC 5570 of 2021. Obliged.
Please, your Lordship. Lordship, on the last occasion, the respondents were supposed to bring instructions.
Annual patta.
Yes, Lordship.
Why you not? You have a policy out there. Don't you have a policy for conversion of annual patta to Miadi? Why you not doing it?
Instructions will be required, my lord.
List the matter again on 4th of October 2023. In the meantime, the Mr. Arbor Pujari appearing on behalf of the Revenue Department shall take appropriate instruction as to whether any steps have been taken by the concerned authorities for conversion of the annual pattas of the petitioners to Miadi. It is made clear. Mr. Barbadari, instruct these people, do it if it is possible. If it is not, you inform us. But keeping people in balance, hanging only unnecessary litigations. Yes.
Dispute here is regarding the land compensation amount who is entitled for. For that reason, my lord, I have preferred a petition before the ADC that was rejected. That is in violation of section 76 of the 2013 Act. So in view of the notification passed by the government, my lord, DC may refer it to the competent authority.
What?
For adjudicating the dispute, my lord, who will appear before the district and session judge, and he is the competent authority.
You have filed an application before the district judge. This is done under the new act.
No, it's not the new act. This is
2013.
Yes, ADC order, they have come up before this honorable court, but actually the district and session judge, Jorhat is the authority as per the notification now. He will take out the matter whether who is entitled, because now the.
That I know.
Yes.
There is that authority is the 64. You are mentioning about 64. I'm not on that. Whether he had filed an application before for the reference.
Yes, ma'am.
Seeking a reference you have filed before the collector.
Yes, ma'am.
This is under 64.
My lord, page 45.
Page
45.
45 ends out there.
Page 46.
Where is your application?
Page 46, my lord, there are 2 plots of land, my lord.
Before the addition LA, a claim petition for respect of granting compensation of Iman covered by so and so. Why is this land been taken?
For upgradation, my lord.
Huh?
Widening the road, widening the.
This is under the national highway?
No, ma'am.
No.
Under what provision?
This has been taken by under.
Government doesn't take under 2013. That I know for sure. They will pay the compensation for 2013, but not. They will always apply 64. So under such circumstances.
Lordship, may kindly peruse order dated 3/12/21 first hearing, my lord. Honorable court.
This order is to be perused, Mr. Counsel. The entire petition, reading the entire petition will be better. Yes, tell me.
My lord. Lordship will kindly come to the last part of the order, my lord.
Yes, until further orders, the common order dated passed by so and so shall remain suspended and further proceedings of these two shall remain stayed. What is this order? 1711.
Page number 60.
Page 60, my lord.
And the last part there in my lord, moreover, without the leave of this court, the land acquisition compensation
You
amount.
notice that the compensation of so and so was awarded to the recorded pattadars, but from so and so to no one had filed complaint at that point of time. Now, no one of late Chuan Bhak's company's concern Iman had filed complaint regarding mutation due in the means of so and so.
My petition seeking reference to the competent.
When was the compensation to be paid? Where is the notice? Acquisition proceedings started when?
One in the year 2013, one in the year 2018.
Under what provision?
1964 Act has been applied. Now they.
64.
Subject and requisition.
Then
Requisition, acquisition.
that is what the problem is.
Lordship,
If it is 64 Act which has been done, why you are not moving under section 12? Asking it for seeking a reference. Why you are asking for more money? What is all these things?
this is what my
That is the problem which happens. In fact, I don't understand. Am I wrong, so wrong, or is it the provisions of wrong is wrong, or the lawyer's understanding is wrong?
Lordship may kindly come to page 60 of the repetition.
Huh?
That will clinch the issue. Page 60 of the repetition.
Yes. So and so is also present with an inform the court in writing
This
that
is
the
the order that
compensation
has
amount
been
in so
given.
and so should disburse among all the sons. On so and so is informed in when writing of the so and so. On the other hand, Sri so and so has filed the petition
Yes.
to the competent authority on referred petition, heard the arguments on so and also gone through the Saya of the Iman. I have seen a copy of the Chita and so in Iman. Notice that the compensation was awarded to record, but from so and so, no one had filed complaint. No one of anyone so and so had filed complaint as so and so. The hearing of the year will be taken up on next day. Then
Now this has been, my lord, impugned hearing. And
Huh?
by that, this order has been impugned in this present.
that has been stayed.
That has been said. Now, the issue here, my lord, which arises for consideration is that, my lord, they are, my lord, agree with the entries in the record of right. Now, if that be so, they say that, my lord, the private respondents, they have wrongfully entered their name in the record of right. Now, the compensation will be awarded to those persons whose name appears in the record of right. But others, they say they are person in the, if they are aggrieved by the entries in the record of right, they have alternative remedies. Either they have to file a civil suit or.
No, that is not. He wants some portion of the compensation.
Exactly.
That is what. So if it is done under that, then why it will come within the ambit of 12B. Now the thing is whether the proviso to section 12 would bar you to approach after 7 years. Because otherwise, rule 80, section 8, because there it says by statute of incorporation, Land Acquisition Act 1894 has been brought in. So Land Acquisition 1894 says that you are to move your application under section 18 within 6 weeks from the date of notice when if you have appeared before the authorities concerned, and if not within 6 months, but not later than that. Now you have approached after 7 years. And why has this court stayed it? No business to stay it. Let the authority decide. Isn't it? First of all, it is the district judge who has to decide. And he has only to make a reference. So let him make a reference. And why have you filed it here? And that at 510, I have to take it because of you. Now tell me how much cost should be imposed upon you for the stay? How much? You have employed such a precious advocate. See, Mr. Sharma is there. Pay him 25,000. Cost?
My lord, can I take it up tomorrow, my lord?
No, this is dismissed.
No, my lord, my only.
Dismissed, and I'm directing here. I'll pass the order. Dismissed. Dismissed? No, it is disposed. I will direct the authority to make the reference under section 12B to the district judge, keeping the point of limitation open. Disposed. 52 cost? 25,000? Yes. Oh, Bakizai proceeding. Where is it? না মই ফিক্স কৰাটো এইটো আউটপুট দিব লাগিছিল এইটো ইমান শুনি মেলি ললো anybody Mr. Sharma
Lordship, this is the instruction we have written.
well is it pending is not missing from the court as
Oh,
stated in the synopsis this
that
case is
certificate
long
debtor
pending
was
without any
unable to trace out.
money could not be traced out in the address area the matter has been Iman. What is the next date accordingly so and so intimated the honorable Iman as well as who is present in the court on the date and the since there is no progress of the case due to non-receipt of proper address of the judgment.
The address, because of their address.
Logical court matter that he received the copy and that is why this is matter before.
Is there a paper publication possible in the Bakizai proceedings?
Paper publication.
Let him give a paper publication and then get it done, isn't it?
Lordship, that will be better.
Do something to that effect. Something can be done on that.
Initially, the judgment debtor appeared before the law.
He appears, now he doesn't appear. Understood? So we'll do one thing, taking into account that the proceedings have been stalled only for not being able to serve it. I've asked them that to approach the district commissioner, Karbi Anglong, is the Bakizai authority.
Madam.
Who is the Bakizai authority?
The deputy commissioner, Karbi Anglong,
Is he?
2 numbers of representation was filed.
Shall proceed with the said Bakizai proceedings and see as to how the proceedings could be brought to a logical conclusion. Huh? But whether it is possible to take by way of it, just find out.
Lordship.
We'll have it not today. We'll have it on 14th. 14th is closed. 21st.
21st.
This is the matter on 21st on which date Mr. H. Sharma, the learned counsel appearing on behalf of the district commissioner Karbi Anglong shall apprise this court as to whether in the Bakizai proceedings substituted service is permissible
Lordship.
as per the code of civil procedure.
Like the paper publication.
Huh?
A paper publication.
37.
Like that.
The instruction so submitted is kept on record and marked with the letter.
But even then, Lordship, how that, if he, in spite of that, if he doesn't appear, how to recover the amount?
Then my headache is less.
Lordship.
The burden in the High Court is
37 orders.
I will get that.
what are they good? Yes, any important order?
Lordship, 2 weeks time may be granted to file the affidavit in reply.
You will got all these things. I mean, any important order? Huh? Item number? 41.
41.
Yes, what is it?
In this matter, after a long struggle, the interest written from the 2002 till date has ultimately been calculated and on that you will kindly see the date 23.
Mr. You are appearing?
6 weeks time was taken for disbursement of the interest. Interest ultimately will calculated. It is deposited in the court. At that time took time 6 weeks time. Already more than 12 weeks passed. Not the interest paid till now.
Hey, item number 41, na?
Yes,
41.
Yes,
41 we'll take it up again on 14th. Not 14th. On 21st. You are there?
Madam,
Why you are not paying?
there is some budgetary constraint, madam, we'll pay some amount.
No. You are supposed to pay within 6 weeks. What is all these things? Pay this amount.
Already will be passed.
How much amount is this?
5 lakhs for
And who is the department?
ACC, madam.
Yes, good, that's good. This is
Now the ACC is doing very well.
Yes, it's doing well, my lord. Not that matter. But we'll pay some amount. Let it come on 14 months, I'll get the instruction, madam.
Mr. J. Roy appearing on behalf of the respondent contemner shall apprise this court on the next date as to when the amount would be as to whether the orders passed by this court has been duly complied with. List the matter again on 16th of August. Get your instruction when you are paying. Any urgent order matters? Any compliance to contempt matters? No.
Lordship, item number 51,
What is this?
it is for the correction of the order.
What has happened?
In fact, the name of the company is arising from the matrimonial MSCT appeal. Name of the company is New India Assurance Company. There is
Continue.
typological error, the insurance company.
Hmm?
Typological error occurred instead of the assurance, insurance. So that the authority are not accepting the certified copy.
Where? This is not my order. This is Justice Madhav Nandi's order. You are asking for that?
Yes, yes.
Well,
It is listed
list
in
the
wrong-
matter before the appropriate bench. I can't correct somebody else's order. Anything else? No.